My Lord, my Lordship's kind leave to mention an extremely urgent matter. My Lord, your Lordship heard this matter on the last occasion. My Lord, it's appearing as item number 80.
Item number?
80. My Lord, your Lord, this is with respect to the tender matter. Your Lordship had fixed it today, my Lord, fairly at the top because they're going to open the tender, my Lord, on Monday. But it's fairly down and I don't think it's going to happen, my Lord, today. Your Lordship's kind pleasure to kindly specially fixes it tomorrow in the morning. Kindly, my Lord, it's on notice. That
80 may
put
not
us,
be reached. Yes.
my Lord.
Kalki fairly at the top.
Topic. Fairly at the top, Bulletin, Your Lordship. So grateful, Your Lordship.
In an excruciating circumstances, my Lord, I am carved, my Lord. The monthly list item number 1910 may kindly be upgraded to some extent, my Lord.
What's the urgency?
My Lord, urgency is, my Lord, permanent injunction is there, everything is there, they are encroaching the property. And pond is being filled up by them.
Give the number, please.
Lord, I am mentioning second time, my
Hello.
Lord. It's a new contempt matter. Lord, file is lying here. Your Lordship kindly direct to appear tomorrow, my Lord.
File is lying here.
Yes, yes.
Yeah.
Lying here. I'm grateful, my Lord.
My Lord, there are three matters. One is contempt, another one is injunction applications, another one is representation and considerations for lease matter.
They are all in the monthly list.
Yes, my Lord.
Give the numbers.
Well, maybe permit to mention item number 2. My land is on the other side. But I have
Item
some
number
difficult.
2.
I don't have to. Stupid, I have some difficulty. Your Lordship takes it tomorrow, my Lord.
I'll let me call the matter. Let me
Fine.
call the list.
I am instructed from my client not to proceed in this matter, and we're praying for
Give
it.
the numbers. To be mentioned, non-prosecution, Jayanta. To be mentioned, non-prosecution.
Maybe Lordship's kindly to mention a matter, Your Lordship. Matters appearing as item 199 in Your Lordship's daily list, Your Lordship. The matter I'm mentioning for upgradation. Your Lordship, the matters with regard to property that has been occupied by the state respondents completely illegally in pursuance of a leave-in license agreement. The agreement expired 2 years back, 2021. They are still not vacating the property, Your Lordship. Therefore, I'm mentioning
It's
for
in the supplementary list and there is no imminent urgency.
Your
Wait
Lordship.
for your turn,
Since
it will be taken up.
2011, the matter has been
Please
going.
wait for your turn, it will be taken up.
Your Lordship, may I be permitted to mention a matter, Lordship? The matter is the authority reluctantly withheld from issuing the land loser certificate in spite of having
It's in
acquired.
the monthly list.
Yes, Your
Give the
Lordship.
number.
Re-
Yes, call the raised list, please.
Lord, in terms of your Lordship's last order, Lord, we have paid that amount not on Monday within time, as per your Lordship's order. মোবাইলটা বার করো অর্ডারটাও নেই টাইমে Lord, my Lord, on the last occasion, kindly have a look at your Lordship's order, my Lord.
Yes, yeah,
Yes.
After the matter was dismissed for default, the notice
Lord,
has been.
10 years the interim order was subsisting. After the matter was dismissed for default, they initiated proceeding. On the 14th, when the matter was moved before your Lordship, after taking leave, after they are informed, they dispossessed us. At 10:30, they were informed. At 1, they dispossessed us. And your Lordship's my Lord directed us to deposit the entire amount and directed my learned senior friend to take instructions whether the possession should be returned back to me without claiming any equity. Because, my Lord, the possession was taken when the matter was sub judice before your Lordship. We have paid the entire amount on the 18th itself.
Yes, Mr. Chattopadhyay.
Yes, my Lord. They were given lease for 9 years.
I'm not
Lease
on
expired.
merits.
Yes, lease.
I'm not on merits at the moment.
Yes, my Lord. Question
They
is
have
this.
deposited the amount.
They have deposited the amount. Question is this, my Lord. The main ground for issuing the interim order which they have obtained is that the West Bengal Government Premises Tenancy Regulation Act is not applicable to them. They have shown a judgment of this honorable court. My Lord, this matter went up to the Supreme Court. Supreme Court has been pleased to hold that if a building is constructed there, then the act will apply. Therefore, the question of granting any further
Judgment. দেখান
So kindly see paragraph 29.
Sona promoter says.
Same judgment, my lord, the matters went up to the Honorable Supreme Court. Well, kindly come to paragraph 29. May I read?
Today the issue was not whether they
No,
will
no.
return possession or not.
My lord,
29.
29.
No, on the basis of this was the principle on which.
These are the
No, I
principles on
can-
which they got the interim order
Yes, wait
and
for-
continued.
Let me see also, this is an unreported judgment, let me see also.
But may I read that? But thus, when the eviction proceedings are initiated, admittedly, the land in question did not contain any structure. If the bare land is let out to the government of the undertaking and it continues to be a bare land, as on the date of initiation of eviction proceedings, the incident of such tenancy cannot be governed by the provisions of the Act. And such a tenant cannot be evicted by the taking aid to the provisions of the Act. The material date is the date of initiation of the eviction proceedings. Has the respondent number 1 put upon construction on the plots of the land leased to it, and if the eviction is sought under section 3 of the Act for violation of some other clauses of the lease deed, or upon satisfaction of the conditions contained in subsection 1, 2, and 3 of section 3, the proceedings would have been maintainable. As noted above, the subject matter is the appeal is continues to be bare land, but that matters bare land. But here, my lord, here, my lord, this is kindly see the I have taken the photograph. There
are constructions.
there are
That is
constructions. Construction.
Whether section.
But one thing, my lord, may I
Let him-
may
let him
I
argue.
come? But even if that, my lord, our land policy of the government is this: if the position is taken, it will go to the board, and board will consider all the applicants. They will grant. But I have talked with them.
So,
They say that if they pay the current rate of the lease and that they take a fresh lease, we can grant them. If they choose that, I instruct my client to go on that. Well, the fresh lease, the rate is there. Well, you'll also kindly see the rate. I have also brought. Kindly see this.
please, please hand over a copy to.
I'm
Learned
giving. ma'am, two copy.
So that he can take instructions and come.
So kindly see this.
Because he needs to take instructions. on this.
Next page,
Yes.
page 23. Page 2, item 23. Behala Industrial Park.
Yes.
30 lakhs per kata for 99 years. If they pay all other paying the pay, we shall grant them.
Lord, the earlier rent was 4 lakhs per kata.
Maybe, my lord,
Lord,
that
In the year,
Lord, when the lease was granted, lease to
the lease was granted, my lord, in the year
1989.
1989 and for
Then-
9 years.
No, we cannot both talk together.
No, no.
Final understand answer.
1989.
Then I will say. Now,
This is
Lord,
a
they are,
Well, this is a
there are
proposal from. the
yes, yes,
side.
I'll consider and come back.
So
I
please
will,
consider
I'll
and
take
come back.
instruction and come back.
And instead of just considering this and coming back, please come back on affidavits.
Yes, my lord,
I'll
I shall
extend the-
affidavit.
kindly
Itself.
Kindly extend the interim.
Short
order that your
affidavits?
Lordship passed.
You'll say kindly short affidavit, otherwise my land will keep vacant, my idle vacant. He will not get, other will not get.
You see
Interim
the-
order remain until further orders.
Until further orders, you also kindly fix a short date of affidavit. Otherwise, this is
I don't mind. If they file an affidavit in short date, not.
But what I'm asking, paying for is this.
Land
No,
is-
cannot বলছি। But
Land
the
is
land,
lying in limbo, no one.
limited land,
I cannot
limited
oppose on
land,
that.
they are not using, we are with my other person.
But if my land friend files within 2 days also, that is for him to decide.
No, no,
I am-
7 days I shall take.
Yes.
heard
and 7
learned
days for
counsels
me.
For the parties.
And Lord, we'll kindly record that in the pendency will not stop the parties from proceeding with the negotiation, the offer given by land.
Yes,
As you lordship. If
And
they,
in the extend the interim order. Now, may I take your lordship's leave? Lord?
Learned counsel for the
ছবি তুলে নাও, ছবি তুলে নাও।
WBSIDCL
দিয়ে দেবো।
submits that the
তুমি নেটে পেয়ে যাবে।
company
হ্যাঁ, ওখানে ছবি তুলে নাও।
proposes to the company is agreeable to execute a fresh lease in respect of the property in question in favor of the petitioner.
With present rate of rent.
Yes. At the present rate of rupees 30 lakhs per kata for 99 years. Within bracket land. Stop. Paragraph learned counsel for the petitioners seeks to take instructions in this regard. Mr. Dey, you're appearing for the state. Will you come back with an affidavit in opposition? Is it necessary? You have nothing to say. The company seeks to use an affidavit in opposition in this
My lord,
matter?
if your lordship hears the matter without affidavit, I can, because the main ground of the interim order is that act is gonna apply.
Shall I fix a date for, at the motion stage itself?
Yes, your lordship fix the
If they are
matter.
not willing to give an opposition, my lord, I cannot force my learned
My
senior.
lord, because my lord, if they, if your lordship fix the matter, it is an urgent matter. If your lordship fix the matter for any other, next week, any other day, your lordship fix it.
Next week will not be possible.
I'm just seeking that if my lord fixes a date, will I not to let the interim order be continued
It will continue
until further orders, my
Yes.
lord. That's my only,
Paragraph, let the matter appear under the heading, group one, it's a group one motion.
my lord.
One motion on 11th October,
11th of
October,
October. Yes, my
this side of the vacation. Paragraph, the interim order granted earlier is, interim order granted earlier shall continue until further orders.
lord. Whichever is the earlier, my lord, until further.
Until further orders.
I'm not fairly at the top. You'll say, if you lordship, it is in the bottom, my lord, it will be
Let me
hard.
see, let me see. All matters cannot be taken fairly. Let me see.
Grateful lordship.
And please consider the
My lord,
proposal and come
I
back in
will
the
take
meantime,
instruction
right?
from my client regarding this, my lord. Grateful lordship.
Oh, one more line. Tendency of the writ petition, writ application shall not preclude the parties from proceeding with the from negotiating with regard to the proposal made by the respondents. So you can continue that also.
My lord,
in the
my lord,
meantime.
definitely, my lord, definitely. Grateful lordship.
Next,
One second, calling item number 2.
I am for the writ petitioner,
yes.
but I am being led by Mr. Ghosh, my lord. Mr. Ghosh has mentioned, my lord, earlier that, but he has some difficulty, my lord, today, my lord.
What application is it?
This is an application for addition of party.
But I will show, my lord,
You are the intervener.
I am the, my lord, the writ
No,
petitioner.
he's the writ petitioner. I
Right.
seek to intervene in the writ petition. That's why I filed an application. 2 applications I have filed. One is the application for impleadment and one is an application for vacating an interim order, which has been passed in this writ petition.
Subject to allowing the first application.
Subject,
Of course, of course. That's why I said, mother, first impleadment.
He is in some difficulty today. Please come back.
Let it be not
Come
today, my
back
lord,
after
tomorrow.
vacation.
My lord,
No, mother, I'll tell you, Lordship, why. The reason, my lord, there is a connected public interest litigation with respect to the same property in which the writ petitioner claims an interest. Well, in the PIL, the bench of the Honorable Chief Justice, over the year, my lord, has passed several orders, reports have been filed, not only by the Kolkata Municipal Corporation, also by the HON'BLE Land Authority, because this is the HON'BLE land of the government. There it has been held, well, in those reports and in the PIL, that the petitioner has no locus, he had applied for a lease, he has no right to grant a lease, that has been rejected, he is carrying on unauthorized construction, all this is a part of the report. Now, my lord, nothing has been brought to the notice of this court, the orders of the PIL. And in fact, my lord, pursuant to previous orders passed by this court, reports have been called for. Now, if your lordship will see our case in the PIL, I am the applicant in the public interest litigation. The corporation, the HON'BLE authorities, the land authorities, and a developer who's developing the entire stretch of HON'BLE land, and he's just one of the occupants. They are all hand in gloves. Well, all of them are together. This is the purport of my PIL.
Who is appearing for the state?
then I will, my lord, demonstrate before my.
One and the same,
That,
Mr.
my lord,
They all appear for the
also
same parties. In there, they're appearing for somebody else. Here, they are appearing for somebody else. But the issue is that, my lord,
I'll
the
hear it out on the
But the
basis.
cause of
Any
action
day-
of this writ petition,
Engage in court number.
And you have no clue about the case.
My lord, I just
Right.
got the brief. I just now got the brief. Just kindly.
Have you heard the submission of learned counsel? A PIL is pending with regard to the, say, please take instructions and come back.
my lord,
Please take
May I,
note
my
of
lord?
this at least.
my lord, one thing, my lord, I shall demonstrate, my lord, that the cause of action in the PI and this instant writ petition is entirely different.
naturally
But
different.
the reports of the Milwaukee District
Mr.
Magistrate,
Minister,
Kolkata
ready?
Municipal Corporation,
Yes,
Very
not tomorrow. I'll fix a date in that case. Come back on 12th October.
12th October.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th October. Please come with necessary instructions.
My lord, may I seek one indulgence? My lord, the second application, which is the vacating application, my lord, there some annexures have become illegible. Well, it can kindly allow us to withdraw it and file afresh. Can do.
File a fresh set of elections on next date.
The addition to be
Please file a fresh set on the next date. That will suffice.
Very well. We'll bring a fresh.
Withdrawing and
We'll do
filing.
that. We'll do that. By a supplementary, we'll do.
Yes, then item number 3.
Petitioner, rather applicant? No one. Not today. It's a substitution application.
Item number 4.
Well, I am for the petitioner, my lord. I pay for 2 weeks time because service is not affected and there is some correction in the cost title. Therefore, 2 weeks time may kindly be granted on behalf of the petitioner.
Cost title has been corrected.
Corrected, my lord. Then the service is not affected. Kindly, I pay for 2 weeks time, my lord.
Slash petitioners. No. On prayer of the applicant slash petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th October.
16th
1/6.
October. Yes.
Please serve in the meantime.
Yes, madam. Yes.
Serial number 5.
My lord, item number 5, I am appearing for petitioners, my lord, led by Mr. Owen Banerjee.
Yes,
My lord, I am praying for short passover. my
not
lord.
possible in this book. You do not pay for Passovers. Please make your submission.
আমার submission নেই, আপনারা বলুন না। আপনাদের appeal তো dismiss
An
হয়েছে,
appeal
ভাই।
is pending, Mr. Dev.
No, my lord, yes, started, the appeal is dismissed as withdrawn, my lord, in court number 5.
Because my lord, that as Sushovan Sindhu has not any authority to file that in file.
So that has been withdrawn.
Yes, my lord.
Yes, my lord.
I declaration for that. My lord, I will-
Have you sought liberty?
Yes, my lord.
Yesterday, what happened for the last 2-3 days, just in bench presiding of Justice Bosak, the question arose the authority of Sushovan Sengupta and Subilpal. Now they failed to produce. Yesterday, legal eminence was present over there, and they said that they will withdraw all the whatever they have filed, they have withdraw, and they will file afresh, barring the appeals which were filed when they were in the panel, but they will not allow to continue with those appeals. So therefore, the appeal filed after their depanel, that was liberty was given to withdraw and to file
File
afresh.
afresh, yes.
That is the thing. Because in my matter, this was happened.
Yes.
This is
There's
the,
a content matter.
yes.
So the same order will apply.
No,
that
in
way also.
contempt matter, my lord, that was filed when they were in panel.
So they
So
cannot
court said,
continue.
but that's why court directed them, my lord, to engage another lawyer. That's why the matter is today is not appearing. Possibly it will appear next week.
So let them take some time, yes. On prayer of the alleged contender, the matter is adjourned. Paragraph, let the matter appear under the. Will you come back after vacation?
Yes, my lord.
Since an appeal is contemplated,
Lordship, lord.
let the matter appear under the same heading on 28th November. 28.
Serial number 6.
Actually, I am the petitioner, Lordship. And last occasion, Lordships, they prayed time for compliance of the Lordships, order Lordships, and Lordship fixed 2 days, Lordship. But till now, they did not comply as a Lordship.
Yes, who is appearing?
My lord, I am appearing on behalf of the alleged contemner.
Yes, both.
Now, my lord, alleged contemner number 2. My lord, the notice has been issued upon the alleged unauthorized documents as per Highways Act. Lordship may kindly cease. My lord, this is my instruction. Lordship may kindly cease page 10.
What was the order?
My lord, the order passed by your lordship is, my lord,
And last occasion, your Lordships.
my lord, I have filed one affidavit of compliance on the last occasion. In that matter, my lord, I have annexed the order passed by your lordships. My lord, the order is at page 8 of my affidavit of compliance passed by your lordship on 16th of August 2022. Your lordship has been pleased to direct. Lordship may kindly peruse page 9 of my affidavit of compliance. Writ petition is disposed of, directing the 6th respondent to consider and dispose of. So, my lord, initially the 6th respondent, my lord, there was a deliberation that this the jurisdiction is with my client, not.
The form of affidavit stating this. This is not on affidavit.
No, my lord, this is there was no such. My lord, I have annexed the order passed by your lordship on the last occasion.
No, no,
Lordship
that's
may
fine.
kindly. Yes.
But where is your affidavit of compliance?
My lord, that was filed on the, my lord, this regarding this notice, my lord, only, my lord, I am with the report.
Only
Come
notice
with
has
an
been
affidavit
issued.
of compliance, because since it's a contempt application.
Fine.
Yes. Section 10(1) notice has been issued. You are
Issued.
not aware?
Kindly fixed on the, giving the short time, Lordship, they are only the notice has been
My
issued.
lord, short time, I don't understand. There is a procedure under the act.
I agree, Lordship,
10
but the
days,
Lordship.
15 days notice has to be given.
Yes, Lordship, I agree,
Shall I
Lordship.
make it not today? Can you come back with an affidavit tomorrow?
My lord, lordship kindly gives me a week's time. In the meantime, my lord, the period is expiring on 21st also. The period mentioned in the notice. So, my lord, kindly take it up on the next Wednesday,
is
subject to, my lord, subject to your lordship's convenience. My lord, I will come back with an affidavit of
Learned counsel
compliance.
for the alleged contemner submits that pursuant to the order of this court, notice under section 10(1) of the West Bengal Highways Act 1964 has been issued upon the alleged encroachers. Learned counsel seeks to submit affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 27 September,
My lord,
next
27th.
Wednesday.
Next Wednesday, my lord. Lordship, this report may be kept on record. Subject to your lordship's, my lord, convenience.
প্রথমেই করুন, report submitted on behalf of the alleged contemner is taken on record.
My lord.
Please come back with an affidavit.
My lord.
Seven.
Lord, I am for the petitioner. My lord,
Yes.
this is first time
Will
happening.
you serve and come back?
My lord.
10th October, you can serve by then.
My lord, 10th October.
Then service adult. 10th October.
Lord,
Under heading Group 1 motion, serial number.
My lord,
6.
the land of the petitioner utilized
Who is
by
this
the
appearing?
government. Well, I'm coming. By the,
Who is
Mr. Utilized by the government, Mala, for the purpose of road. Mala, in the, my lord, in the year 2019, this honorable court passed the order to make an inspection and what measurement is to be, that compensation has been paid. My lord, that has not been complied with, so my lord passed an order on 4/7/2023. My lord, kindly see the my lord's order, 4/7/2023. It is shocking to note that the order passed by this court on 10th July 2009 has not been complied with as yet. So DM is directed, has not been carried the complied with the order passed by this court. Such amounts to contempt of court. The district magistrate Paschim Mendipur is directed to personally appear before the court on the adjourned date and so cause as to why the rule of contempt shall not be issued against him for non-compliance of the order by the court. Well, DM present. But my lord, there is two part in the order of 2019. My lord, it is exception petition, no? My lord, kindly I filed the exception petition. My lord, what from my lord, page 8 of the exception petition,
Let me just go through the order, give me a minute.
2019 order, my lord, 10/7/2019. A page 9 in order in portion. Last paragraph. Since,
Give me a minute. You've submitted the affidavit of the
well, I'm
exception.
giving exception, yes, my lord, last occasion I filed.
Yes, exception.
Exception, my lord, which is page 8, 2019 order passed by this honorable court. On-
Yes, that I've seen.
Yes, like two part in this order. First, we will inquire regarding my lord utilization of land,
And
and
compensation.
second part is compensation. But my lord, in the my lord, the so-called my lord reply given by the DM, my lord, the DM has my lord rightly my lord has my lord misleaded this honorable court in not answering of the so-called the second part in respect of compensation in question. Well, here I find my lord in the report. Nothing has been disclosed, but my lord, my
What was
unfair.
the inquiry was held in your presence?
Yes,
Where is the inquiry report?
my inquiry report, my lord,
Page 11? Yes.
page 13. Page 13, my lord.
Let us hear the state about these two points.
My lord, that is my lord, joint page, that is page 11.
Yes.
তুমি শোকজটা দেখছো দাদা? ও শোকজটা দেখো না। এই রিপোর্টটা থেকে পড়ো, রিপোর্টও আছে আমার কাছে। এক্সেপশন পিটিশন থেকে পড়ো, আমি দিয়েছি ওটা।
So the BLLRO admits that there has been utilization of the plot.
Yes,
Yes.
my lord. There is no any-
What are the steps taken next?
Now, my lord, it is that step taken by the who is the requiring body, that is the PW.
Have you taken any
No, no,
steps?
no, বলো 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 বলো।
No, করলে হবে, হ্যাঁ, yes, yes. My lord, it is found that the existing metal road, that is the road is under the PWD roads. Now the PWD roads will, my lord, send a proposal before the land action collector.
From 2019, it is
Has-
2023.
Please,
my
sir. Has such proposal been sent?
No, my lord, as because my lord, this is the, there is the, that this portion of 0.1650 acre of land over the, that is, my lord, was utilized by the PWD roads. Now, my lord, PWD roads will send that order is not in the, my lord, you have to ask for it.
The first order says take necessary steps for
Now, my
compensation.
lord, the DM has not any authority to take steps. Now the steps taken by the executive engineer of the PWD or the assistant engineer of the PWD roads.
Steps shall be advised in the light of the inquiry.
Yes, ma'am.
So the DM can advise the steps to be taken.
Now we can advise, my lord, according, but according to the procedure, my lord, this procedure is, my lord, that the who is acquiring the land, who is utilize the land, he will send a proposal to us, my lord, that is the land acquisition collector. And land action collector will go according to the proposal, according to the procedure of the proposal.
But here in this case, DM report, my lord, this my lord project my lord, West Bengal WBSRDA. This is the Pradhan Mantri Gramin Sadak Yojana under. But it is not the PWD road. But it is the West under the Pradhan Mantri Gramin Sadak Yojana.
Then, my lord, he can show the gram.
Yes, my lord, report is existing.
Sadak Yojana, there is a provision of acquisition or not.
My lord, land has been utilized.
No.
Now,
Land has been utilized.
no point.
I only want to see the color of money.
That there is a provision.
He
Of
is
the
not
acquisition by
asking for
whom?
acquisition, Mr. Dev. He is only wanting money for his land.
Who is giving
The government has
that is
taken
not
away his
the-
land, he
That is
needs the
not the
money.
DM's road. That is
And-
not the proposal of DM. It is the.
You are representing all the wings of the government. So we cannot pass the buck like this and
My lord,
let
he
the
must-
petitioner
he must-
suffer.
He stated.
One
that-
department says no, the other
My lord, this
department,
is
that is
the-
not.
This is not the lands of the PWD roads. That is the land of the panchayat. Now, my lord, that is it. Pradhan Mantri Gram Sadak Yojana, my lord. Now, my lord, my learned friend must prove that there is a provision. Who will send the proposal? Must, my lord, prove
The
that.
petitioner is not supposed to know that, Mr. Dev. The
My lord,
government is
petitioner
supposed to know.
No, my
Whoever
lord,
has
I
taken the
can't-
land is supposed to know.
If I know, my lord, I can submit that. My lord, there is no any provision to give any, my lord, there is a provision, Gram Sadak, Pradhan Mantri Gram Sadak Yojana, that the land, that the road which is existed, that will be, my lord, in the
Made
metal or
pakka,
anything else.
yes,
Nothing
yes.
else. No, nobody can, my lord, extended or other things, my lord, that can't be.
But here there has been an encroachment.
Encroachment for that reason, my lord, who that PWD road, that is the Panchayat road, that is the municipality said, my lord, that secondary.
On the
Jila
report
Parishad-
itself, page 13.
Secondary
Page
Jila
13, my lord, in my lord,
Secretary Jila Parishad informed that-
exception report, my lord, the what DM has said. Page 13 at the bottom. Page 13 at the bottom. It is pertinent to mention that WSRDA reported that there was no correspondence received regarding the related issue at any stage from the petitioner, and also under the guideline of Pradhan Mantri Gramin Sadak Yojana on dated August 20, 2013, that the Pradhan Mantri Gramin Sadak Yojana 2 does not provide any funds for the land acquisition. Well, who said to utilize my land without due process of law? This is our property.
But the DM says the road was constructed as per proposed alignment and guidelines.
But without due process of law? A DM is sole responsible without any due process of law. Land has been utilized. Who will pay the
DM doesn't
compensation?
talk about any encroachment. The joint inspection suggests that there was encroachment.
Yes, ma'am.
So the state is the best person to say who will
Yes, ma'am.
take responsibility.
That should be complied. 2019 order should be complied with.
It's money for his land, nothing else.
Only color of money,
Petitioner is
nothing more.
not supposed to know the procedure or the authority.
There is any, my lord, if the land is in the procedure of the PWD roads or other things, my lord, that is in another process, that is sent proposal. But in the Pradhan Mantri Gram Sadak Yojana, my lord, there is no any proposal. We can at best, my lord, those metal road can be demolished.
Restored to
Yes,
my
my lord.
original.
We can at best demolish that. In another case, my lord, I am facing another court, my lord. That is we have stopped the encroachment and demolished all the portions of the petitioner's land.
So I'll record your submission and dispose of.
No, my lord, that is another thing.
How
I
can
must
I
take
direct
the-
demolition?
I must.
But what is existing?
That is the. That
2019 order?
দাঁড়াও না। My lord, it can be solved. Otherwise, there is no any provision for to solve the problem. Otherwise, Panchayat will purchase the land, but there is no such proposal for Panchayat or other things. So must, no, my lord, and Jila Parishad already said that they have not any interest about that.
No, but the petitioner cannot be made to suffer due to interdepartmental
Only for that,
communications.
that reason, my lord, another. My lord, Jila Parishad should take the responsibility, but Jila Parishad said that I have no interest. That the Parishad do not have any issue in this land related matter. That is the page 12, my lord, that is my report, last line.
Yes, I've seen that.
That is the problem, my lord. It should be Jila Parishad should take the
The
responsibility.
last report, page 13. But to comply my lord's order, my page 13 is the last report by the concerned, my lord, the DM. And below said 16.50 land has been, my lord, utilized by the government for the purpose of road, well, which is, my lord, at page 15, start from page 14. And what are the last portion, my lord? After proper field measurement is found, the existing metal road passed over the subject land of on the road occupies approx 1650 acres of the land over the plot 150487 belonging to the Rayat of Muja of the Dhanosara jail number 899. It is admitted fact. DM was present on that day for inquiry.
Have you implemented the Panchayat as a party? Because if it is Pradhan Mantri Gram Sadak Yojana, it's the Panchayat who is responsible, isn't it?
Yes, madam. He should not, Malad, encroach any portion of.
Yes, yes.
And there is
But that has been done.
That is done, Malad, in that, for that is Malad, in another court, Malad.
Yes, page 4, Malad 10, Pradhan. Is Panchayat Authorities Party?
So, Malad, Pradhan
10.
come.
10.
Pradhan was served, has not come. Let there be a direction for restoration of the land to the Pradhan in favor of the petition.
In original,
Malad,
in nature.
that is not- Malad appeared today.
But because he submitted this before your lordship.
No, Malad, in another court I have submitted. As because my direction was there, Malad, in such fashion. That we have already stopped.
My dispute to submission, 2019 order is still existing, no appeal. Here in this case, my lord, now 2 terms of order, first order, my lord, first inquire, and what portion of land has been acquired, utilized, and second part is my lord regarding compensation, which is my lord in my lord exception report, exception petition. Here Honorable High Court
That's
directed.
why I will direct the Pradhan to either pay compensation to you for encroachment of your land or restore the land to its original position.
Yes.
And Pradhan has not appeared despite service.
Yes, sir.
So serve a copy of the order to the Pradhan.
As your lordship. Kindly direction about the Pradhan, why not this order has not been passed by this honorable court?
So you want to keep it pending? Not necessary.
As your lordship.
Heard learned counsels for the parties. It appears from the report in the form of affidavit submitted on behalf of the state respondents that a joint inquiry was held by the district magistrate in presence of the petitioners.
In presence of all Pradhan as well as BLLRO, all
and
were
other
present.
And other state authorities pursuant to the direction of this court given on 10th July 2019 and the field inquiry report submitted by the Block Land and Land Reforms Officer on 14th July 2023 demonstrates that about 0.1650 acres of land of the petitioners has been utilized for the purpose of construction of metal road stop. The report of the district magistrate and collector, Paschim Medinipur also suggests that the road was constructed
It is also indicating the
Under
report of the
the-
BLLRO.
Pradhan Mantri Gram Sadak Yojana scheme. Paragraph, it is submitted on behalf of the state respondents that constructions under the Pradhan Mantri Gram Sadak Yojana scheme are done by the concerned Gram Panchayat. Paragraph, in view of the above, this court is inclined to hold that since admittedly a portion of the petitioner's land has been encroached upon by the Gram Panchayat, being the 10th respondent herein, the 10th respondent should either pay necessary compensation to the petitioners for utilization of their land or restored the land to the petitioners in its original form. Yes?
Restored to its original.
Restored to its original form. In favor of the petitioner. Restored the land to the petitioner, bolechi to. Yes. Paragraph. The writ petition is accordingly disposed of, directing the 10th respondent to either pay compensation to the petitioners for utilization of their land under the Pradhan Mantri Gram Sadak Yojana scheme, or restore the land in its original form in favor of the petitioners. Let it be within 3 months.
Malo, one thing, Malo, in
3
submitting.
months should be sufficient. Mr.
Malo,
Singh.
Malo, in respect of compensation in question, Malo, DM is the assessing authority. In consultation with the
The
DM.
panchayat has to.
Because
He must show the law, Malan.
say the law, say the boita deto. Ke compensation payment korbe?
In Pradhan Mantri Gram Sadak Yojana, who will pay? Not
Malo,
normal
because-
compensation.
Because my lord here in this case, my lord,
The
DM
state,
is the acquiring
the
authority
state is the best person to say, sir.
as your lordship. Then Malo, I have to come again
Uh,
as your lordship.
Within 3 months from the date of communication of this order. Paragraph, since the 10th respondent is not represented, comma, a copy of this order along with copies of the reports submitted by the Block Land and Land Reforms Officer and the District Magistrate be forwarded to the be furnished to the 10th respondent by the petitioners at the earliest. Since they're not there, furnish the entire copies to them.
Yes. But the
Writ
problem
petition
is
accordingly
this, my lord,
disposed of.
but 2019 order still existing. But there is no appeal preferred by the government.
Yes, they do not
Because
intend to
there-
prefer an
here
appeal.
in this, that order, this honorable directed the DA to invest for the payment of compensation.
At that time,
part is
was
still
it-
existing.
At that time, was it brought to the notice of the court that it is under the Pradhan Mantri Gram Sadak Yojana? No,
My lord,
you have not brought it to the notice of the court at that time.
Because,
That's why the
Malak-
court give a blanket direction. This is the general direction that the DM will consider. But since this is under a particular scheme which is conducted by the panchayat has to do the needful.
as your lordship.
Next.
Matter is disposed of. I'm grateful to your lordship.
I am appealing for the state, my lord.
Yes. Have you served this? So you are appearing for the state.
Lord.
Petitioner,
Uttam Kotal.
who is appearing for the petitioner? You are appearing.
Kamdil. I am for the private respondent.
What about the petitioners? No one.
Our state. No, no. But several times was taken on this matter. Doctor, civil suit is pending. Let's kindly come page 10, my lord.
None appears for the petitioner. No accommodation is sought. Dismissed for default.
Grateful.
10. Mr. Pan, you wanted to use an exception.
I have used an extension, my lord, as well as the reply. Now, my lord, before I proceed with my writ petition, I like to request your lordship to have a look at the report filed by them. What is their only defense? Then I will come to the writ petition.
My lord, yesterday we got the exception, my lord. Yesterday only we were being served the exception, my lord. I require a couple of days, my lord, to go to the exception because the thing is there,
What's
but
served
yesterday
already?
only I have been served.
I am really, this is very shocking afterwards on our part.
There's nothing, my lord, on yesterday only the thing have been given, my lord.
Served
Should
a
have been
couple of
served, yes, ought to have been. What is?
Because my lord, I have to go to the entire thing and then make out because there are 14
Sir, I
matters.
understand, my lord, possibly I should correct myself. My learned friend was not there. When he is made available, then we could have served him. He was not made available for service.
My lord, day
How
before
could I serve?
yesterday, I got a phone call at 4 o'clock in the evening, my lord. I had urgent work. I had to leave for some other court, my lord. At 4 o'clock, the call was there. Thereafter, on the next day, yesterday only, I was there available.
Let
And
us not
thereafter,
go
I
into
was being
that.
served the
Come back.
copy, my lord.
Are you filing the exception today? It's not on record.
And I'm sorry to disturb you, lordship. Sorry.
Exception used by the petitioner is taken on record. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th October. So these are all the similar matters.
Milord, serial number 20, Milord.
All one by one, please give me this.
Milord, item number 20. Item number serial.
11. I'll call one by one.
Milord.
11, my lord, on behalf of the Metro, my lord.
11. Who is appearing? Serial number 11.
My lord, on behalf of the Metro, my lord.
The same order?
Yeah.
Grant the same order. Act করে যাবো আর একটা করে exception নিয়ে নিব। সব একই order হবে। 12.
Milord, I'm filing my exception.
My lord, yes,
Same order?
yes, my lord.
Same order.
My lord, my senior is not available right now, but Pulokesh Bajpai, Mr. Pulokesh
You are
Bajpai,
appearing for whom?
respondent.
Respondent, which
I am
respondent?
submitting Shudashar, item number 12.
Which respondent?
Shudashar Trexim, Union of India, others.
My lord,
Pulo-
Mr. Vajpayee, I was been allotted. Thereafter, Mr. Vajpayee said he will be representing the Metro Railway. So he has not come today. He has sent out the junior, madam. So let that be taken because the report was not filed in this case, madam.
Item number 13 is something else.
No, I am.
What is the name of the item number 13?
Item number 12. I am.
It is item number 12.
12 or 13? What are you saying?
I am item number 12.
But 12, you said you were there.
Yes, miss, I was there, but Mr. Vajpayee, he
You
did not.
filed a report earlier.
Yeah, I had.
He told me to submit the.
How he can file another thing. What you are filing?
Supplement.
Sir, my
It's a supplement.
senior only told me to.
Supplementary of what?
Shudashar Trexim.
Are you appearing for the Metro Railways in this matter?
Yes, my lord. 14 matters have been allotted to me, my lord.
Yes.
In that, my lord, I can
So
see.
how is Mr. Vajpayee intervening?
In the last occasion, my lord, he came up and made out a submission before the court, my lord.
Very confusing submissions. Or sometimes he is saying that I am appearing for 14. Sometimes he said another person is been allotted.
Item number.
My lord, my senior friend should not get out so agitated in regard
Yes,
to that. my lord.
definitely, because
But
you are
he is
talking
there.
about the service. So this matter we solved long before upon Mr. Vajpayee. Now he said that you have not been
I
served.
find Mr. Vajpayee's name recorded
Yes.
in all the earlier
No,
orders.
he was served earlier. Now after my service, now they are trying to supplement their report. Is it, Malad, I putting it to myself, is it permissible under the law? They have filed a report. I took the exception. Now after getting my exception, they are filing a supplementary exception report.
I think you have served the exception to.
Yes.
My lord, in regard to Mr. Vajpayee has,
Have you served copy to Mr. Pan?
you have,
Yes.
copy has been given.
You have served copy. You have received copy of today's report.
And we have got the exception, affidavit of exception yesterday only. So my senior told me to take
Same
time
submission.
for going through that.
My lord, can it be taken?
Report, এটা 12 এ করুন, হ্যাঁ, same, একটু change হবে, হ্যাঁ, 12, হ্যাঁ. Report in the form of affidavit submitted on behalf of the Metro Railways is taken on record. Autoগুলোতে exception ছিল. Are you using an exception today in this matter also? A paragraph exception used by the petitioner is also taken on record. Paragraph on prayer of the exception হবে এটাতে. On prayer of the Metro Railways, the matter is adjourned. With the matter, appear on the same heading, ওই একই। এতে exception টাও নিয়ে নিন।
E. But I will not use any reply or something like that to this because they have annexed only the documents. Rather, I will rewrite those documents also. So in this matter, Mr. Bajpai is appearing or who is
Let
appearing?
Mr. Vajpayee appear, my lord, because he is already there.
Only in 12.
Only 12. My lord. Because if required, I have to serve again. And I
Oh, yes, yes. I don't think so because his junior friend is there.
Serial number 13.
13, who is appearing?
My lord, Lily Holmes has been allotted to me.
Yes.
I am appearing on behalf of the respondent.
Join the. Again.
12.
14.
Sorry,
14.
14.
I'm filing my. I have served.
One by one.
On behalf of the Metro, my lord.
Same order. Same order.
The key.
15.
We have tried to serve Mr. Rahul Torkar, but he was not available so that we could not serve.
The exception.
Exception.
Where is he?
And he is also not appearing.
Rahul Sarkar, Sanjeev Bhattacharya.
Affidavit, exception used by the petitioner is taken on record. Paragraph none appears for the respondents. Let the matter appear under the same heading on 9.
And may I do one thing, my lord, to avoid all the complications, my lord, I will serve direct to the department this exception. So that we not take the plea. I have received the copy. So
My lord, if my learned friend wants to start out, I am ready to come out with
To
the.
the department, he may not receive at all.
No, but I will serve them directly because otherwise the gentleman, the learned advocate will come and say that I have not received. So we will be in the soup.
Please take care. Like, these
Yes,
are all legal
I'll take.
issues. Let us
My
take
lord,
up the
I hope on
matters.
Mr. Rahul Sarkar is the junior to Mr. Sandeep Bhattacharya. He expired recently, I hope.
Yes, yes.
That was the reason he was admitted in ICU, my lord. The reason he made out one submission also in the last
Who was
occasion.
admitted in ICU?
Mr.
Mr.
Sandeep
Bhattacharya?
Bhattacharya, yes, ma'am.
That I know, yes.
Yes. I think so. He is a junior to him. That may be
Please
that.
find out.
Yes, I'll
Yes.
find out it out.
Again, we will try to serve.
You are getting some time, 9.
Yes,
So in the meantime,
again,
please serve.
Otherwise, my lord, precautionary measure, my lord, I will serve to the department. My lord.
Next.
Serial number 16 to 26.
I have served.
On behalf of the Metro, my lord.
Same order. 16 to 26 are taken up together.
Milord,
You are appearing.
My lord, only item number 20.
20, Milord, Union of India / Metro Railway.
My lord, item number
Milord,
20, 25. I'm not there, my lord.
Milord, this is my Milord report on affidavit, Milord. May I leave to file.
Jointo,
I have already served.
Jointo, item number 20 te report in the form of affidavit. Number to likhe hote. Report in the form of affidavit aske jama. No. Exception. এবারে তো উনি আছেন। আছেন।
আপনার স্লিপ গুলো আলাদা করে লিখে ওইভাবে দেখা যায় না সব পরিষ্কার করে
Give us separate slips, otherwise it will be difficult.
আর লিখতে পারবো না আমরা পরে এসে মেনশন করে বলবেন যে আমাদের
So many matters together, so
পরিষ্কার করে কোন কে কত কোনটা লিখে
you are in 20 and 25.
20. Milord, only 20.
Only 20.
Only
Very
20.
good, very good.
Union of India / Metro Railway. Milord, allotment made by the Ministry of Law and Justice. Union of India is the secretary, railway, and 2 is the Milord Metro Railway.
File it up. File it up. Affidavit,
জয়ন্ত বাবু এটাতে এক্সেপশন ফাইল করেছি
no exceptions copy no
Exception. Milord, my learned friend, after this, Milord, I submitting this Milord, my report, they have also filed exception today itself. So I have not received a copy.
This is the copy I'm serving.
Let it, they'll all appear on the same date. Please come prepared.
Milord.
My is kept on 9th, no, my lord.
But I repeat, the matters need to be taken up. So many matters pending.
Yes, ma'am.
Please be ready on the next occasion.
Issue is very short, my lord. Issue is very short, section 80 of the Right to Fair Compensation and
please-
Transparency Act.
Please
that-
come back on the next.
My lord.
Next.
Serial number 27.
My lord, may I be hand up this, my copy of my exception, my lord?
Similar matter.
Yes, yes, 17 to 25.
I'm in 27 now.
Exception.
In all this,
In
all
all
these
these
matters, please file them.
পরপর সাজানো আছে।
Join the 25 of the exception. Exceptions করে দেবেন ওটা। Exceptions করে দেবেন। Yes, 27.
27.
And about the petition in this matter,
Yes.
my lord, state was supposed to file, my lord, the
Who is
report.
appearing for the state? You're appearing. Yes, where is your report?
Till now, my lord, I have not been served with any report.
Several extensions granted.
In spite of the, there was a direction by your lordship, my lord, to serve me an advance copy.
Mr. Shorter, you need to be a little more diligent. You've not served the copy as yet. So we miss another date.
My lord, I have copy of the
Advance copy, Mr. Dev.
My lord, they are coming late, my lord, after that.
Only one day advance, that is suffice.
এই তোমাকে বললাম না নিয়ে পাঠিয়ে দিও মৌরিকে এখন জজে অন্য কথা বলছি কেন মাই লর্ড অন্য কথা বলছি মাই লর্ড ইন আইটেম নাম্বার 27 মাই লর্ড দিদি এটা নেন না গো 27 মাই লর্ড
You want to come back with an exception or something?
নো মাই লর্ড
You just want to go through this.
Yes,
Yes.
এই নাও তিনটেই
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph copy of the
সবগুলো
report
দিয়ে
is
দিচ্ছি
laid
তুমি
over
নিয়ে
to
আমাকে
the
হচ্ছে
counsel
আমাকে
for the petitioner.
এক্ষুনি করে দিচ্ছি
In court
দিয়ে
is
দাও
said.
ওই তিনটা
Paragraph on prayer of the petitioner, the matter is adjourned.
তিনটেই
Paragraph, let the matter appear under
No,
the
no,
same heading on 13th October.
ইয়েস মাই লর্ড নেক্সট এই তো বাবাকে এই যে দিদি
Same matter, my lord. 27 to 29, my lord. Your reports are on record, my lord. Same order in 28. Rajiv, same order. Same order.
29.
দিদি এটা দিয়ে দে রাখো
Rajivu, apply petition. The same order.
30 with 31.
I am for respond number,
31, same order. Yes,
respond number 7 and 8.
which matter?
30 and 31. Oh, my lord, I seek some time for, there is a fault on my part.
In 30,
Because, yes, my client came to me, so I asked them to prepare a map. So they have prepared a map, my lord. Yesterday I have been served with a map. I'm trying to give me 7 more days time, my
30,
lord.
Mr. Bandhavia.
But 30 and
30,
31, 30 and 31.
Oh, the
31 action. 30 and 31, my lord, can you give me some time, my lord? This fault on, purely fault on my part.
Learned counsel for the petitioner seeks extension of time to use an exception to the report submitted on behalf of respondent, on behalf of the respondents. Paragraph, let the matter appear under the same heading on
Well, there is no such report on that. The Honorable Justice Miller Vishwajit Basu was pleased to direct the respondent authority to take measurement and conduct a joint inspection, my lord. Accordingly, that joint inspection report has been, my lord, DHA.
7 and 8 has submitted a report. It is on record.
Actually, the 7 and 8 has no role in the matter. I shall.
My lord, in 12 I was there, but I was stuck up in a matter, my lord.
Which matter?
His junior submitted with your lord.
Yes, yes, yes. She was there, no difficulty.
They have given exceptions, so I will go
All
through
the
it.
matters will appear on the same date.
My lord.
Yes. Let this matter appear on 11th. 11th October.
না না এটা তোমারটা না তোমারটা নাই
হ্যাঁ 30th
ওগুলো নাই
30 and 31, 11th October. October.
11th October. Serial number 32.
My lord, item number 32 in this matter, my senior Mr. Kunal Sahant is appearing for the petitioner and saying for short passover.
Not possible in this court, I'm sorry.
My lord, he is on the way.
Passover is not possible in this. For the respondents, who is appearing for the respondents in 32? No one. I can grant you an adjournment at best. Passover cannot be granted. None appears for the respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph let the matter appear under the same heading on 11th October.
Kitchen.
33.
My lord, I am appearing for the petitioner. My lord, Lordship had directed the Metro Railway Authority.
Yes, I'm sorry.
My Lordship had directed the Metro Railway Authority to file the report. My lord, pursuant to your Lordship's order of 23rd of February. My lord, thereafter, the matter was heard by your Lordship on 28th of August, wherein my lord, they had filed a report.
Yes.
But my lord, the report does not contain any documents. Now, my lord, the only document is that there is a minutes of the meeting which shows or records that there is no amicable resolution between the parties. Hence, my lord, the writ petition has to be heard. Now, my lord, I met Mr. Guha Thakurta yesterday because this matter was running in the list. He is led by Mr. Bikash Ranjan Bhattacharya.
Yes.
My lord, he told me yesterday that Mr. Bhattacharya is not in town because he's in Delhi, my lord, because the parliament is on. My lord, I will not, in that case, in the
I am Saurabh Gothakuratas Junior. I need, he is in another court, so not today.
But anyways, Mr. Guha Thakurta told me that Mr. Bhattacharya is leading him in this matter. His name records in your Lordship's order. In that case, may it up.
After vacation,
Yes, my lord, we can come back after vacation.
on prayer of respondent number 2,
Yes, my lord, all the respondents, they are paying for all the respondents.
on prayer of the respondents, the matter is adjourned. You are for the petitioner.
Yes, my lord, I am appealing for the petitioner.
Let the
Petitioners,
matter
my lord.
appear under the same heading on 24th November.
24th November. Great.
Appearance, please. 34.
Lord, I am for the
Yes.
respondent. Lord, on the last occasion, my lord.
Petitioner,
Ma'am, I am for the petitions, my lord.
My lord, this is that matter, my lord. On the last occasion, I started my submission.
yes. You have made your submission on the earlier occasion.
Earlier occasion, I started. To some extent, my lord, I have submitted, but I
Yes.
could not finish it. To recapitulate the facts, my lord. It's basically, my lord, challenging the order of cancellation. This writ petition has been filed. My lord, some facts, my lord, may I precisely, my lord. The petitioner was offered an allotment of plot of land for setting up a healthcare related institute, my lord,
Yes.
on 23rd November 2010 on leasehold basis. Thereafter, on 4th May 2012, possession was handed over. Thereafter, a lease deed was executed on 27 July 2012 stipulating the terms and conditions by which the allotment would govern. In the lease deed, there is a specific covenant stipulating the period within which the construction to be completed. And it was also stipulated that on failure to make construction within the time stipulated, the consequence which would follow, my lord, the cancellation of the allotment and the plot will be resumed by the authority. My lord, knowing fully well the constraint, the specific covenant in the lease deed, my lord, the allotee did not take any positive steps, even either to commence construction or less. It would appear from the writ petition, my lord, at page 92 that mutation was obtained in 2013, allotment was made in 2010, possession given in 2012, July 2012 lease deed was executed. In January 2013, mutation obtained, and the building permit, which admittedly the petitioner obtained, which would appear at page 108 of the writ petition, that was obtained on 17 July 2015, which is beyond the period within which the allotee was to make construction.
Yes.
And during this period, not a single letter was written to the authority intimating any of his difficulty in making construction. So, my lord, when it came to the notice of the authority at 110, Lordship will find that the KMDA issued a notice.
Demand, yes. Yes.
Lordship, may I, for at the cost of repetition, my lord, may I place this before I go to that page, my lord, may I place the one clause of the lease agreement. This is very, very important. At page 100, page 51, I'm just placing the relevant portion. That is clause 2.5.
Yes. Yes.
May I read, my lord? To commence construction of the proposed building within 24 months from the date of execution of this deed of lease or handing over of possession, whichever is earlier, and to complete construction and commission the health care related institute proposed to be set up on the demised premises within a period of 36 months from the date of execution of this deed of lease, provided, however, that the authority may, at its discretion, on an application being made to it by the lessee and on payment of such fees or penalty by whatever name called as may be fixed by the authority from time to time, grant to the lessee such extension of time to commence and or complete and commission the project on the demised premises for such period as the authority may determine, provided, however, that upon failure of the lessee to comply with such covenant to set up, complete construction and commission the project within the time originally fixed, or as may be extended by the authority, the lease of the lessee shall be liable to be terminated by the authority, and the authority shall be entitled to re-enter into or upon the demised premises and obtain possession thereof. And after such re-entry and resumption of possession, the authority shall be liable to refund to the lessee a sum equivalent to the premium paid in terms of this lease, less 20% thereof to be deducted as the service charge. So, my lord, in this covenant, my lord, it is made clear that within the period mentioned, the LOT has to make construction. The time may be granted if it is applied for at the sole discretion of the authority. And on failure to make construction, the lease shall be liable to be terminated and the authority will be entitled to re-enter in. And the refund will be, after resumption, refund will be made. There is a specific clause. In spite of that, my lord, Lordship will find at page 108, I referred to, that the petitioner obtained building plan in 2000. Eight. 108. This is stressed from 107, part of 107. Lordship will find at 108, the stamp, the building permit was obtained on 17 July 2015. Even if the date of execution of lease deed is taken, then within 3 years, it also goes beyond the stipulated period. So violation took place on the date of obtaining permit itself. And it is an admitted fact, my lord, that no extension, no prayer for extension was ever made by the petitioner. Then your lordship kindly turn to page 110.
Yes.
This is the case made out in the writ petition. I am placing it, and this petitioner deliberately suppressed some facts which are very much material. Lordship will find that after this building permit, all of a sudden, without disclosing the relevant fact, page 110 has been annexed, as if that without any prior steps taken, this demand was raised, which is under challenge in this writ petition. And this is the demand raised by the authority. May I read this? Demand notice for delay in construction. The undersigned, the backdrop of this, my lord, that has not been disclosed. I will make submission on that. The undersigned is directed to request you to deposit a sum of rupees, it was so and so, as the penal charges for delay in construction and service tax thereon, so and so. And that was directed to be within 30 days, deposited within 30 days from the date of issuance of this letter. Allotment shall deem to be cancelled if the payment is not made within the time mentioned. Lordship will find the next page. Next page is the same, my lord, repetition. Lordship kindly come to page 112. This is the reply to this demand. Lordship kindly come to the second paragraph of this letter. This is written by the petitioner to the CEO KMD. We have not started the construction due to our deep financial crunch. This is the only explanation offered. We have applied for bank loan for the said construction, which is in progress, and it will be sanctioned shortly. And also, we have got the sanction plan in late. We plan to start construction very soon without. So admittedly, on the day of issuance of this letter, there was no construction. They have not started. It is stated in the writ petition, my lord, And this reply was considered by the authority, and authority was not satisfied with the explanation offered, and then 119 the cancellation letter was issued. This cancellation letter was issued on, Lordship, kindly take note of the date, 30th March 2016. And this writ petition has been affirmed on 2nd May 2022. 2016 to 2022, and there has been no explanation with regard to the delay in filing the writ petition. Here in this writ petition, the petitioner has made categorical statement that no opportunity of hearing was given to them before issuance of the demand notice. This fact has been suppressed by this petitioner. Lordship, kindly take up my affidavit in opposition.
Yes.
Yes. My lord, I have taken specific ground at page 2, paragraph 4. The ground, the petition is for suppression of material fact and the ground of inordinate delay. In paragraph 4. Then the facts relating to the allotment, I am not placing all those. Lordship, kindly come to, may I read from paragraph 8. Before that, Lord, regarding the clause I have quoted and the allotment and possession, all this. The allotee, being the petitioner, failed to commence construction within the time stipulated in the lease deed aforesaid. The allotee, by its letter dated 2nd May 2014, prayed before the authority for extension of time up to 5th November 2014 for commencement of construction on the demised land on the plea that their proposed building plan was pending for sanction before the KMC authority. This fact I have shown to your Lordship at 108 of the writ petition that building permit was obtained by them in 2015. Before that, before obtaining this letter was issued, but there is no mention in the writ petition. They have applied for, they have prayed for extension. And then, Lordship, next paragraph, by a memo dated so-and-so, number so-and-so, dated 11th November 2014, issued by the Deputy Secretary Estate Unit KMDA, the petitioner was served with a notice to show cause as to why the allotment in question will not be cancelled for breach of the terms and conditions contained in clause 2.5. I have read, that clause. In response to the said show cause notice, the petitioner filed its reply on 19th November 2004. This fact was also suppressed. Seeking to explain the delay for non-construction and categorically agreed to pay such penalty within the reasonable rate as may be fixed by the KMDA for grant of extension of time to commence complete and commission of the project on the demised land. Lordship, for a moment turns to the annexed P2 and P3. That is at page 18, Lordship, kindly, which I have read at paragraph 8, their prayer. Lordship, kindly come to the relevant
R2 and
R2. That is letter dated 2nd May 2014 of the petitioner. The above plot was given possession to us on 5th May 2012. We were to start construction on 5th May 2014 as per the terms of the above mentioned letter.
We have taken all necessary action for the construction of the building, including submission of the building plan to KMC. The file is now in Municipal Building Committee and the final sanction of the plan is expected shortly. Since the file is presently pending with KMC, we would request you to grant an extension for 6 months, that is 5th November 2014, by which time we will commence construction work positively. This letter was never disclosed in the writ petition. Then, my lord, the show cause notice which we issued, they have not only suppressed but made a misleading statement that we have no opportunity was given. This was the show cause notice at page 19, and the next, Lordship, kindly turn to the next page 20. I am not reading the letter as a whole. Lordship, kindly come to the penultimate paragraph.
Yes.
Our earnest request is, please give us some time as above mentioned, and whereas according to the condition at clause 2.5 of the lease deed, we are ready to pay such penalty within the reasonable rate as may be fixed by the KMDA. Grant to extension of time to commence and complete and commission the project on the demise. So they undertook to pay the penalty as may be imposed by the authority for grant of such extension. On such undertaking, my lord, given by the petitioner, Lordship, kindly turn to the next page at page 21. This is letter dated 24th March 2015. Subject is permission to initiate construction of the house at EKADP in favor of the petitioner. This to inform you that the competent authority has agreed to consider your prayer. This is the prayer he has made with an undertaking. To consider your prayer for initiation of construction of the house of plot of a EKADP in principle on the following condition. There are two conditions were put, my lord. Number one, A, you shall have to pay the penalty as per the existing rate of KMDA up to the date of initiation of construction completion. Number two, you will have to give an undertaking on non-judicial stamp paper within 10 days of receipt of this letter that you will initiate construction within 6 months as per the lease deed from the date of permission. Here 6 months time was prayed for, and it was undertaken by the petitioner that they are ready to pay the penalty for such grant of extension. These conditions were put. But the petitioner neither gave any undertaking. The authority, after waiting for some time, my lord, issued this demand notice. As they agreed to pay the penalty. So as per the existing policy, this demand was raised. That is at page 22, which is under challenge. Lordship will find the demand in the writ petition also. That is at page 112 in the writ petition. This is the same letter. This was not responded. Then Lordship turned to next page 23. The final notice was issued. That was, and then the petitioner issued the letter I have read, that has been annexed in the writ petition also, 23rd November 2015. They have stated, Lordship, I repeat, this second paragraph. We have not started the construction due to our deep financial crunch, no other ground except this. Then, in view of this situation, the matter was placed before the Land and Flat Allotment Committee, held on 21st December 2015, and the committee, after deliberation on this aspect, Lordship, kindly come to page 30, the relevant portion.
Yes, 30.
আমি মনে করি দিচ্ছি তো সব page 34.12 regarding this petitioner, Genesis Institute of Management and Technology failure to pay the penal charges because the petitioner did not pay the penal charges demanded. The committee opined that no waiver of penal charges for extension of time may be considered. After detailed discussion, it was decided that the Honorable Chairman KMDA has given extension of time on payment of penalty. The matter of cancellation of allotment of land of Genesis Institute of Management and Technology due to failure to pay the penal charges within the stipulated scheduled time may be put up to the authority for decision. So LFAC has decided to put up this matter before the board. And accordingly, the matter was placed before the authority, that is the board, in its 179th meeting. Lordship will find it starts from, resolution starts from page 34. It held on 29th December. Lordship, kindly come to the relevant portion at page 41.
41.
The resolution of the Land and Flat Allotment Committee was placed. That is at Lordship, kindly come to the third paragraph, 4.12. For 4.12. For means Miller, that refers to the as in the number Miller 4.12. Genesis Institute of Management and Technology failure to pay the penal charges. The decision, Lordship, next line.
12 has been struck out.
No, it was not struck off, my lord. It was marked. That is why the photocopy has come.
Can't be.
Wait, I'm extremely sorry, my lord. May I read, my lord? I understand, my lord, that copy without editing that was given. Genesis, that is for 4.5. 4.5, my lord, just now I placed the resolution of the Land and Flat Allotment Committee, that 4.12. In that regard, Miller, the authority decided the next line. I read, Miller, Lordship will have to take trouble, Miller.
Yes.
The authority decided to cancel the allotment of Genesis Institute of Management and Technology. So board has decided to cancel that. Accordingly, the cancellation letter was issued at page 45, which is also under the annexed in the writ petition, which is under challenge, that is on 30th March 2016. And then Lordship will find page 46, my lord, at a glance, may I read, my lord, as per terms of the lease date, my lord, after cancellation, we are to refund the money after deducting 20%. That was done at 46. Lordship will find that this was issued along with the check, but it was not encased, my lord. Then, my lord, another attempt was made at page 42. Again, the amount was sent.
42.
46. 46, the first refund advice was issued along with the check. It was sent to the petitioner's address, but it was not encased. Then, my lord, 48, Lordship will find in June 17, another attempt was made to refund the money along with the check. Lordship will find the photocopy of the check at 49. That could not be done. Again, my lord, Lordship will find that at page 50, the resumption was done. And page 51, the Lordship will find that the land has been resumed by KMD. So now the question arose, my lord, admittedly in the writ petition, the petitioner sought to make out a case as if no opportunity was given to them. But facts remain that it is the petitioner itself. In 2014, it prayed for time. Authority considered their prayer initially, subject to certain conditions. they in writing agreed to pay the penal charges for extension of time as they have prayed for. Authority on certain terms and conditions, my lord, agreed to. Demand was raised. When the demand was raised, they have not paid the demand, the amount demanded. So in the demand notice itself, it has been stated that on failure to pay the demand charge, the cancellation will follow.
Yes.
So the cancellation letter was issued. And that too in March 2016, whereas the challenge to the said cancellation order has been made in 2022. After a long period, 16 to 22. More than 5 years after cancellation was done, the writ petition has been filed, and without offering any explanation for the delay in filing the writ petition. Well, after this reply, after this opposition was filed, the petitioner came up with a supplementary affidavit that was affirmed on 20th February 2023. But here also in this supplementary affidavit, although, my lord, it is the settled principle of law, my lord, that by way of a miscellaneous application or affidavit, one cannot improve his case.
Are you referring to the exception?
No. Supplementary affidavit.
Perhaps, my lord, it is not, my lord, lying with the file.
Not on record.
it is served.
So many papers, my.
Yes.
So here the explanation tried to give, my lord, in paragraph 5, 6, and 9 is completely irrelevant to the case made out in the writ petition, so to be made out. And in supplementary affidavit, the petitioner tries to make out a case of discrimination as a defense. My lord knows that it is the settled position of law, my lord, that one cannot be permitted to improve his case by way of filing a miscellaneous application or affidavit. In Brahmada's case, that has long been settled. The petitioner, in order to justify its suppression, this effort has been made. And the question of discrimination does not arise, my lord, since each case has to be decided on its own facts. There cannot be any similarity. And the Article 14 also, my lord, cannot be, my lord, applied in a negative manner. That is, the negative equality cannot be claimed. My lord, it is no use of placing this in exception, my lord, that fact of suppression has not been denied. This has not been denied. Petitioner tries to avoid that, but could not deny it, that no such prayer was made or the authority issued show cause, and they have given reply. These three documents, these three very vital documents, they have completely, on the ground alone, on the ground of suppression alone, this writ petition is liable to be dismissed, my lord. My lord, that apart from this, may I now come to the point of law, my lord. Here, the cancellation has been done by the authority in exercise of the powers which is derived from the contract itself. After the offer was made and it was accepted by the petitioner, the contract was concluded. That was reduced in writing the terms and condition in the lease deed. So the terms of the lease deed is binding upon the parties, equally binding on the authority as also the lessee. When it is the contractual obligation of the petitioners to make construction within the time stipulated, and on failure of making such construction within the time, the consequence as has been stipulated in the covenant, that must follow. On this, my lord, before going to other cases, my lord, an identical case came up before your lordship, and lordship heard this matter and decided dismissing the writ petition. अरे बाबा दुटो करे कोথায় আরেকটা কপি কোথায় বুঝতে পারছি Case of this, below the facts of this case almost identical to this case also. Damodar. Both of us advocation.
It's not identical. Still, what my planet friend is relying upon.
Damodar was carried till the Honorable Supreme Court.
Yes. After your lordship's order was challenged in appeal, the Honorable Appeal Court affirmed this. While affirming, lordship will that portion, may I place this? No, it is lordship will at page 20, lordship will find that after affirming this, Honorable Justice Banerjee has added some points. Radhakrishna bar karo. Radhakrishna bar karo. দুটো কপি বার করো। হ্যাঁ শেষ In Damodar's case, there was license. Here, lease. This is the only difference. Here also the demand was raised with the rider that non-payment of the demanded amount will attract cancellation. And accordingly, cancellation was done. Page 22, paragraph 4.
Yes.
The relationship between, may I read this?
The relationship between the appellant and the KMDA was purely contractual. The appellant was admittedly in breach of a contractual term. The contract license deed authorized KMDA to cancel the license deed upon breach by the appellant of any of the covenants in the license deed. KMDA exercised such right and cancelled the license deed. Prior thereto, in terms of a policy formulated by KMDA, it agreed to exceed the appellant's request for for extension of time for making construction upon payment of penal charges. Situation is the same in the present case also. The appellant pleaded inability to such charges. Thereupon KMDA cancelled the license. In my opinion, KMDA need not have to shown any indulgence to the appellant, and the indulgence shown did not in any way affect its contractual right to terminate the license. While operating the realm of a private contract having no statutory flavor, like in the present case, the state or a statutory authority should be allowed to act as any other private party, and their action should not be interfered with lightly as being unreasonable or arbitrary. The competent authority in KMDA has framed a schedule of charges to be levied on defaulting allottees of land as a precondition for extension of time to make construction. It is a financial policy of a statutory authority with which the writ court should not easily interfere. The schedule of charges in terms whereof KMDA demanded money from the appellant for granting extension of time to make construction is not under challenge in the present proceeding. Here also not. There is a clause in the license deed to the effect that any relaxation granted or indulgence shown by KMDA to the licensee shall not in any way prejudice the rights of the parties under the license deed. That clause I have not placed, my lord. That is also there in the list deed. I will show to your worship. Parties under the license deed. KMDA offered to extend time for construction against payment of charges. Such offer was not accepted. This indulgence shown by KMDA in no manner affected its rights to repossess the land in question upon termination of the license, in view of the appellant's failure to make construction on the land within the contractually stipulated period, or even much beyond such time. Accordingly, in my considered view, there is no infirmity in the order under law. Miller challenging this, Miller, my learned friend's client went to the Supreme Court, SLP was dismissed. So thereby the lordship, the order passed by your lordship was got affirmed. Are the relative of God. I shall not place the paragraphs, my lord already in that Damodar's case considered the judgment of Radhakrishna Agarwal and Bereli. I am just handing up. My learned friend also knows these are only two judgments, my lord. I am, because my lord relied on that. My lord, the clause which I read just now, my lord, that is there also. Lordship, kindly turn to the page 75 of the writ petition, because
Writ petition.
writ petition. My lord, that is regarding the relaxation clause, which has been quoted there. It is also here in the list deed.
Yes,
4.2, my lord, got it?
yes.
That any relaxation and indulgence granted by the authority to the lessee shall not in any way prejudice the rights of the authority under the lease deed. That the failure to authority to enforce one or more performance of the so and so shall not. Yes, next also 4.4 also, that the failure of the authority to enforce in any one or more instances performance of any of the terms, covenant and conditions of this present shall not be construed as a waiver or relinquishment of any right or claim granted or assigning hereunder, or the failure or future performance of any such terms and condition and covenant, and such failure shall not in any way affect the validity of this deed of lease or the rights and obligation of the parties hereto. The lessee agrees that a waiver of any term or provision hereof may only be made by a written instrument of modification of lease. That is so. Lordship, kindly turn to the next page. This clause is have some bearings also. 4.6.
Have referred to it earlier.
No, 4.6 I have earlier on, earlier I have not. Yes. The terms and condition of the lease deed of lease shall be subject to the changes of policy of the authority from time to time, and the lessee shall abide by this. So it cannot be said, my lord, the situation is not identical. Situation is identical. There was license deed, yet the lease deed. The relationship between the parties are purely contractual. The parties are bound by the terms of the contract. And it is an admitted fact that there has been a breach. And no step was taken to remedy the breach. Opportunity that was offered to the lessee, that is my learned friend's client.
That's all.
Yes, one more decision will have to have. 2020. You will not allow me to.
He is right, I am wrong. That is the whole submission.
You are not wrong, your client.
My client. My client.
Yes.
Milord, this is on Milord, on maintainability of the writ petition in contractual matter. Lordship will kindly come to paragraph 62. Oh, reference to বলছি ওটা কালকে লিখে নিয়েছিল ওটা কোথায় লিখেছে It is Miller 2022 SCC online SC 1091 ওটা SCC তো রিপোর্ট হয়েছে বলে দেবো
Paragraph 62.
62 onwards. Merely because a writ petition can be maintained against the private individuals discharging the public duties and or public functions, the same should not be entertained if the enforcement is sought to be secured under the realm of a private law. It would not be safe to say that the moment the private institution is amenable to writ jurisdiction, then every dispute concerning the said private institution is amenable to writ jurisdiction. It largely depends upon the nature of the dispute and the enforcement of the right by an individual against such institution. The right which purely originates from a private law cannot be enforced, taking aid of the writ jurisdiction, irrespective of the fact that such institution is discharging the public duties and or public functions. The scope of the mandamus is basically limited to an enforcement of the public duty, and therefore it is an ardent duty of the court to find out whether the nature of the duty comes within the peripheral of the public duty, there must be public law element in any action. Then 63. Our present judgment would remain incomplete if we fail to refer to the decision of the case in the case of Ramakrishnan's Krishnan Mission versus Kago Kunia, reported in 2019, volume 16, SCC 303. In the said case, this court considered all its earlier judgment on this issue. The writ jurisdiction was not found maintainable against the mission merely relevant paragraphs of the judgments are quoted here under. Then it quotes some paragraphs from that 2019 judgment. I am not reading all those. My lord, Lordship, kindly come to paragraph 64.
Yes.
The aforesaid decision of this court in Ramakrishnan Mission, SUVRA, came to be considered exclusively by a full bench of the High Court of Allahabad in the case of Uttam Chand Rawat versus State of UP, reported in 2021-6 ALJ 393, full bench, wherein the full bench was called upon to answer the following question: whether the element of public function and public duty inherent in the enterprise that an educational institution undertakes conditions of service of teachers whose functions are a sine qua non to the discharge of that public function or duty can be regarded as governed by the private law of contract and with no remedy available under 226 of the Constitution. Then your Lordship kindly turn to the 65 is the answer of the full bench on this issue. I'm not reading that. Then your Lordship kindly turn to paragraph 68. Next, please.
68.
68, paragraph 68.
Yes.
In the aforesaid context, we may only say that merely because the state government has the regulatory power, the same by itself would not confer any such status upon the institution, the school, nor put any such obligations upon it, which may be enforced through issue of a writ under Article 226 of the Constitution. In this regard, we may refer to and rely upon the decision of this court in the case of Federal Bank SUVRA while deciding whether a private bank that is regulated by the banking regulation and discharges any public function. This court held. Then these two paragraphs are necessary. Is courts paragraph 33 and 34 of that judgment. In our view, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligation or such obligations of public nature casting positive obligation upon it. We do not find such conditions are fulfilled in respect of a provisions to ensure such activity carried by private bodies work within a discipline, do not confer any such status upon the company, nor put any such obligation upon it, which may be enforced through issue of a writ
under Article 226 of the Constitution. Present is a case of disciplinary action being taken against its employee by the appellant bank. The respondent's service with the bank stands terminated. The action of the bank was challenged by the respondent by filing a writ petition under Article 226 of the Constitution of India. The respondent is not trying to enforce any statutory duty on the part of the bank. Thus, contracts of a purely private nature would not be subject to writ jurisdiction, merely by reason of the fact that they are structured by a statutory provisions. The only exception to this principle arises in a situation where the contract of service is governed or regulated by a statutory provision. Hence, for instance, this court held that when an employee is a workman governed by the Industrial Disputes Act, it constitutes an exception to the general principle that a contract of personal service is not capable of being specifically enforced. Then, my lord, 69.
The conclusion.
Conclusion. After considering all this, that we may sum up our final conclusion as under. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, the body or the person must be shown to owe that duty or obligation to the public involving the public law element. Similarly, for ascertaining the discharge of public function, it must be established that the body or the person seeking to achieve the same for the collective benefit of the public or a section of it, and the authority to do so must be accepted by the public. Even if it be assumed that an educational institution imparting public duty, the act complained of, must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers a right upon the aggrieved party to invoke the extraordinary jurisdiction under Article 226 for a prerogative writ. Individual wrongs and breach of natural contracts without having any public element, as its integral part cannot be rectified through a writ petition under Article 226. Wherever courts have intervened in their exercise of the jurisdiction under Article 226, either the service condition were regulated by the statutory provisions or the employer had the status of a state. Within the expensive definition under Article 12, or it was found that action complained of has a public law element. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to judicial review by a constitutional court, its employee would not have the right to invoke the powers of the High Court conferred under Article 226 in respect of the matter relating to service, where they are not governed or controlled by the statutory provisions. An educational institution may perform functions. Are not governed, controlled by the statutory provisions. An educational institution may perform mediated functions touching various facts of public life and in a societal sphere, while such of these functions as would fall within the domain of a public function or public duty be undisputedly open to challenge and scrutiny under Article 226 of the Constitution. The actions or decisions taken solely within the confines of an ordinary contract of service having no statutory force or backing cannot be recognized as being amenable to challenge under Article 226 of the Constitution. In absence of the service condition being controlled or governed by the statutory provisions, the matter would remain in the realm of an ordinary contract of service. Even if it be perceived that imparting education by private unaided school is a public duty within the expanded expression of the term, an employee of a non-teaching staff engaged by the school for the purpose of its administration or internal management is only an agency created by it.
The
It
same,
is, yes,
Principle has been elaborated.
elaborated. So here also no public law element is involved. It's a purely ordinary contract, bilateral contract. Milord, this so far this contractual aspect is concerned, Milord. These are the authorities, Milord. I have cited, no more. And
Will you take some more time, Mr. Taluk?
Milord, on the point of delay, I must
Will you come back some other day? In that case?
only 2-3 decision I will be
Pick up the
citing.
mentioned matters now. Please come back, sir.
And also on suppression of facts.
My lord, in reply, my lord, I will not take, my lord, so much time of.
Reply time.
Yeah, it will take, my lord, half an hour. Maximum to maximum, I will take, my lord, half an hour.
10 to 15 minutes, Milord, I'll finish. On any.
Come back after vacation.
My lord, actually,
It will take more time. That's what I feel.
half an hour time maximum, my lord. Mr. Taluk will take 15 minutes, I am 15 to 20
Let
minutes.
it be this side of this vacation.
Because, my lord, my submission is, my lord, completed long ago. Lordship greatly appreciate, my lord. I have completed my submission.
That is why I have reminded my lords.
No, you cannot remind my half submission. You will
Well,
place your case.
for learned counsel for the respondents. Paragraph, let the matter appear under the same heading for further consideration on 13th October.
13th October. The time is fixed, my lord. In that event, my lord, it will, my lord, on that date, it would be, my lord.
My lord, accepting 13, Milord, any other day, I have some other matter fixed in other court.
16th.
16th.
16.
16th.
My lord, I beg apology to mention, my lord, with regard to item 32, my lord. 32, your lordship, please to fix the matter on 12th, my lord. My lord, I am not on that, my lord. My lord, they have filed a report, my lord. The election, if I can file an exception to the report, my lord, online direction, if you will kindly pass, my lord. I will follow.
Please come back on the next.
No, I am for the respondent.
Here for the respondent, my lord.
I have completed 34. I cannot go back on other matters now.
Under heading mentioned matters, serial number 321.
I will be paying, my lord, very much enough for spare. Initially, my lord.
Mentioned on the ground of audience, I told you.
Yes.
There is no such.
My lord, let submit. My lord. What has happened, my lord, initially, my lord, on my land, a pump house is there. Non-functioning, my lord.
Number 320. Thank you.
My lord. Evidence. My lord. My lord, in the, may I, my lord?
Yes.
In the, on my land, my lord, there was a defunct pump house for several years, several considerable years. I came up to this honorable court seeking an order, since it is, my lord, defunct, my lord, a necessary order may be passed for removal of the same, so that I can utilize my land in, my lord, its optimal limit. My lord, on the basis of that, my lord, directed to consider my representation. The authority have said, my lord, yes, it is defunction from 2009. Pump said, my lord, it is defunct from 2009. Now the government has sanctioned some amount. They are reinstalling the same. My respectful submission, my lord, on this court, my lord, I have annexed a map, my lord. I have handed over the color map. It is in page 52. The color map I am handing over. My lord, kindly have. This is perhaps this is black and white, and I am giving color map.
Have you handed over a copy to learned counsel?
It is already there. It is already there in the my lord, writ petition. It is there in page 52, my lord. It is in black and white, it is in color. My lord, kindly have a look to the deep well of the pump house, where now it is almost in middle portion. What I suggest, my lord, page 52, is the color I have handed over. It is in the middle portion of my land. It is defunct, my lord. It has been admitted in their order itself. It is 2009 from it is not functioning. So, my lord, after 14 years, my lord, they said, my lord, the 12 collapse. Now they will again both and restart the pump. My respectful submission is, my lord, have a look to kindly in the my lord, in the the corner portion. There is a transformer.
You have donated the land to the
No, nothing. They have utilized the land. This is other aspect of the matter. To, my lord, cut short the matter to settle the entire dispute. What I suggest, my lord, if government feels I am wrong, then I have to proceed with the seeking compensation and everything. My lord, the portion where the transformer is situated, it is triangular portion. It is better, I suggest, my lord, the pump house. Now the pump house means a pump, deep well. It can be shifted to that portion nearby to the transformer. It will be beneficial for all because it is in middle portion. I cannot, my lord, utilize the land. My lord, it is around 8 decimal of land I have. My lord, now the now the pump is at a place, I cannot utilize more than 3 decimal. If this pump is shifted to this area because it is to be bored again.
Towards the transformer, you want to shift?
Yes, no.
Enter pump house. Enter
I
deep
am
well.
showing, I have the picture. And my lord, there are other disputes. This is a single room pump house. It can be shifted.
No, it cannot be.
And pump, my lord, kindly have a look to the order there. It is collapsed since, my lord, 2009. My lord, kindly have a look to page 44, the order. No,
Page
35, 43. Fourth line. It is in defunct condition since 2009 due to collapse of the tube.
Yes.
So, my lord, they have to again bore. So, what I suggest, my lord, if it is shifted to back portion and government has sanctioned certain monies, it is in the first paragraph from fourth line, 20 lakhs and something. There are other factors. Now the area became urbanized. There is no, my lord, hardly any agricultural land. There are other factors. I am not going into that.
So you have purchased the property along with this pump house?
Yes. It was there. It was there, and now
Prior to your purchase?
Yes, but the landowners are also writ petitioner here.
How they can?
Let me complete, my lord. In this position, my lord, I will be disturbed, my lord. Let me complete my submission. My lord, kindly appreciate this line, my lord. The 42, page 42. Last line. The authority what says? However, he could not produce related supporting documents on the land transfer agreement consent paper of that period. Nothing. On that situation, my lord knows, my lord, in 67, there was some difficulties. People cannot, my lord, hardly have any right to raise their voice. My lord, I am not going into that. So, I prayed for compensation and everything. In shifting that, my lord, I am saying, my lord, what I suggest, my lord, it is everybody's say that it may be shifted to in that side of my land, so that, well, in that fashion, my lord, hardly around 2 decimal of land from my 8 decimal will be lost. And now where it is situated, entire land of my 8 decimal, my lord, I am not being able to utilize. And my lord, from the picture, my lord, we will see another picture. There is no, my lord, agricultural land nearby. There is school, government farm beside, nothing. From 2009, it is defunct. When my lord passed order for taking consideration, now they have decided it is to be, and on the basis of what? Some people saying that we are the beneficiary. I don't know. We don't know. We are the local villagers. We don't know who are the local beneficiaries, who told, and how, my lord, even, my lord, up to, they say, my lord, we are the local villagers We know, my lord, last 30, 40 years it is not doing function. They say, my lord, after 2009 it has been function. No documents has been produced. Some public exchequer has been utilized from running the pump to till 2009. I'm not going into that aspect. I only suggest it can be shifted because they are started new boring and everything. So new, and what is the urgency, my lord? They have already stacked the pipes, which is required to be put. Now they are trying to bring the machine to be installed. In that fashion, my lord, my entire land will go. And from the transformer, electric connection will be, so the portion from the transformer to my lord pump house, that land I cannot utilize. So for the betterment of the, if at all, my lord, I have no difficulty. And my lord, to that extent, my lord, pump house is to be there. A person is required to be operated. Any person, my lord, from our end, may be engaged as contractual, anything, whatever the remuneration or the government can pay the money, whatever. It can be adjusted in that like that.
Is that your prayer in the writ petition?
No, my lord, I have taken consent. The client is present, my lord. I have taken consent from my client to that extent. Because, my lord, otherwise, my lord, the compensation, I have paid rent compensation, land compensation. My lord, I suggested, my lord, to my client that in this way, how much you are affected. They say, my lord, they prepared this map, and by the map, it has been understood, my lord, the entire land cannot be utilized. Because not only boring, pipes will be followed from area. Entire land, 8 decimal will be lost. I suggested them that it is for the agricultural purpose. Your maybe some relatives or some persons agricultural land, maybe they say, my lord, total area now became urban. So I have handed over the pictures.
Let us hear
Yes,
the state.
yes.
Yes, Mr. Bandhavati.
Tubewell installed in the deep tubewell, my lord, for the agriculture purpose by the irrigation
But the
department.
suggestion appears to be practical,
My
feasible.
lord, kindly see, hear me, my lord. In the year 1967, petitioner purchased the land knowing fully well, he is, my lord, he is a farmer of the locality. Earlier, he moved a writ petition before this honorable court that his representation to be considered. Page 36, the representation. What is his contention?
Removal.
Page 36, removal of the pump house. Last line, my lord, of the paragraph.
Yes.
নিম্নবর্ণিত সম্পত্তি যেটুকু অত্র ঘর হয়ে যায় তা পুরোপুরি সুবিধে আমাদের জমিটুকু চাষাবাদের সুবিধা হইব এ মতে প্রার্থনা কারণ দৃষ্টি অত্র মন্দির থাকা দুটি ঘর সরঞ্জাম সাজাইয়া লইয়া শান্তিপূর্ণভাবে চাষের বকরি জায়গা ঘরটি সরঞ্জাম ইত্যাদি অবদান পরিষ্কার করে চাষাবাদ করতে পারে ইত্যাদি। My lord, your lordship was pleased to direct the concerned authority to hear the matter accordingly. Hearing was conducted. At the time of hearing, my lord, all the government officers were present, my lord, before the page 42. Starts from page 41, my lord. Order sheet.
Yes.
The petitioner appeared by filing Hajira, last line, my lord. Paragraph 41. Represented by the learned advocate Mr. GHOSH to Bhokalatnama Executive Engineer Satyam Balpur, Agri Irrigation Department, and technical assistant in the hearing noted their appearing. Farmers of 80 Ashbogas appeared in the same hearing on behalf of the master concern. Thereafter, my lord, the petitioner's contention, they have purchased the land in the year 2018 and 2019, knowing to that there is a pump house. Then, my lord, you will also find the last paragraph of that list. The Dipankar Mujumdar Executive Irrigation Bahampur one execution petition tendered that office the record shows the said land is under possession of the government of since the year 1967. The owner of the land agreed to donate the said plot of land to install the deep well in the interest of public services for 55 years. However, he could not produce related supporting documents on the land transfer agreement, consent paper of that period. The date of installment of the Bandhaval is 12th November 1967. That is the date of installment. It was put into operation in 1968.
after serving litigation for about 40 years to around 40 hectares of command area of that motor. It is in defunct condition since 2009 due to collapse of the timber. There is a pump house and an old staff quarter on the said plot still now. An underground water transmission arrangement, that is 10 numbers of water distribution pump chambers having around 1.6 kilometer length RCC pipeline and a distribution tank for serving the cultivated land still exists there. To operate the irrigation scheme, the fields of the 11 electrical line with 50 transformer of the West Bengal State Company. As the farmers of the scheme are very much into cultivation research project for renovation, the state government sector.
But therefore, my lord, there is a pipeline, underground reservoir, that cannot be, my lord, the shifted. It is impossible to shift it. And my lord, last findings, your lordship kindly see. Page 44, that is the findings. There are some observations which are as follows. The fuel installed in the year 1960, the operation time, the statements and documents provided by the secretary should in operation for last year is not true. The time of purchase property installation and other property installation was very much standing on the land. Therefore, they have full knowledge of the existence of a government property over the land. There are around 100 numbers of farmer families from the installation and would be writing. They relate to the government for restoration of the installation. It has already been sanctioned by the government to repair the machines so that we can apply irrigation as a measure, as a process and practice. It appeared that the petition and subsequent. Therefore, it cannot be, my lord, impossible, my lord, to shifting the.
There can be two options. You can take instructions. First option, if you can shift it towards the transformer. Otherwise,
Transformer, my lord, may be shifted. But the pipeline, switcher, my lord, the chambers and others.
Sir, nothing is there.
That,
my lord, I have shown.
মাটি তোলা দিয়ে আছে, তুমি ডিউটি আর মাঠে কোনদিন গেছো?
From
শোনো, আমি গ্রাম
2009,
থেকে এসেছি। আমি গ্রামে
I belong from also rural area. Not that I have got in Calcutta.
the land has been utilized. The land
That is
cannot
too
be
valid.
utilized by the
It is
petitioner.
admitted fact.
Yes, so you have to either compensate the petitioner for the utilization, or the better option which the petitioner suggests, if you can only shift the pump house towards
Pump
the.
house is not possible, my lord.
You can
So
take
far, my
instructions
lord,
from-
I have my understanding, my lord. I have come from the village, my lord. I know what is the practical debate. There are the pipelines, chambers, distribution centers.
To that
Huge
extent,
area,
my lord, can call for a report.
1.6 kilometers.
It can be shifted. It is not that. It is not that.
আর ভাই এত খরচটা দেবেটা কি?
So can you take specific
Government
instructions and come up with a
তুমি
report?
জেনে শুনে কি?
These are the two options. So let the authority decide. If you cannot shift, then you have to pay for the utilization.
That is not his prayer.
Yes, it is my writ petition.
No.
Has to be his prayer. Otherwise, what
Yes.
is the repetition for?
I said so. Yeah, I placed 26.
In the earlier petition, that was not.
Pay rent compensation.
Then compensation 66.
That is, my lord, the second option, my lord. In the earlier petition, what was the prayer?
Removal, yes, I said, no, it is removed.
He has failed, as per the reasoned order passed by the. Then he has shifted to the another.
My lord,
option,
the
my
officer,
lord.
my lord, the officer.
Yes, that is his right.
Yes.
He can do that. It is his property.
Then I have to take instruction whether the earlier, the erstwhile landowners, they have been paid or not. If it has been
And
paid,
you
They are
have-
then he has
also
not.
petitioner here.
And
My
the
lord,
If
they
they
are-
are not paid, then he is entitled.
And the state talks about a donation for which there is no document.
Well, we have no documents, that can, which is my last year's.
So please come back with the report.
And surprisingly, my lord, the officer who says, even 2009, he was not in that office. So everything in superficial way.
Affidavit of service.
And in the meantime, my lord, no, my lord, boring or something, my lord.
The
The erstwhile landowners who have, my lord, they have given the land from who has purchased.
No, they are the
They have
petitioner here
আরে
also.
ভাই, তুমি তাদেরকে তো ছেলেমেয়েদেরকে ধরে নিয়ে এসে party
Compensated,
করো।
sir.
How they are
Yes,
affected?
No interim order.
How
is
they are
necessary.
affected?
The difficulty is If they, my lord, now started pouring, I will be in.
The misconduct of the parties.
My lord, since 2009, it has been defined and nobody complains. When I complain on my land, now everybody is jumping up. So the entire beneficiary and scheme, I don't know. Even no document is there. Who are the, even I assume, my lord, there is beneficiary cultivation. From 2009,
Nothing has happened. Nothing.
nobody complains. And the officer who says 67, my forefather donated, he was not in the office. So everything is fictitious. So that I need, my lord, some protection.
Petitioners seek
Well, it's a government project, if my lord, any order passed with it.
government project stalled from 2009. We are
Yes,
in
but it is
2023.
defunct. It is defunct. If it is, my lord, again restored,
So there is no
the
hurry.
local farmers will be benefited. But if if the land is utilized, he is entitled to get the compensation.
Yes, but the farmers could wait from 2009. They can wait for a few more days also.
Yes.
He is entitled to
No
get the.
further, no further installation in the land.
Well, no installation, but the repairing will work.
Nothing, nothing. Till because
But
the government
what
wants
was
it.
his allegation in the earlier
If it is
petition, my lord?
Government desires
My lord,
to adopt it, then why they
what
will
was the
spend money?
allegation in the earlier petition? It is defunct since 40 years. He has made false statement before this honorable court then.
And it from 2009.
Nine. But what was the earlier
If I say
petition?
so, my lord, if
And
I
it is-
say so, let them produce the documents how utilizing public exchequer, the pump has been shown to be functioned till 2009. I am not
here. It is not correct.
The
He had made
petitioners
false statement before the honorable
seek
court.
removal of the pump house
40 বছর খারাপ হয়ে পড়ে আছে লিখেছে
installed
হাইকোর্টে
in its
এফিডেভিট করে বলে
in their property by the state respondents, which is admittedly lying defunct since 2009. Stop. Paragraph. Learned counsel for the petitioner suggests that if the pump house is shifted towards a
transformer side.
Towards the transformer, which is installed in one corner of the plot, comma, the petitioners shall be able to utilize the remaining portion of the land. Stop. If the pump house is allowed to be reinstalled / renovated in the portion where it now stands, comma, the petitioners shall not be in a position to utilize the entire land. Stop. In the alternative, comma, the petitioners seek rent compensation for utilization of their land.
And land compensation. Rent compensation and land compensation, both.
Rent compensation and land compensation for utilization of the land. Paragraph. Learned counsel for the state respondents submits that it may not be feasible to shift the pump house towards the transformer, since several pipelines and other accessories connected thereto run through the
Pump house.
Connected thereto are installed underground and cannot be shifted. Stop. Learned counsel seeks to take instructions in this matter. Paragraph. Let the matter appear under the same heading on 13th October. Paragraph. In the meantime, comma, the respondents are restrained from resuming renovation / construction of the pump house in the petitioner's apostrophe property. You can take back the photos, photographs. Is it okay? Yes, in the meantime.
13th and in the meantime, up to next day. Up to next day.
Yes, come back, let us see what the report says. We can resolve it.
Yes, I suggested, madam. In that case, madam, only 2 decimal will be there, and whatever the value, the government can pay, whatever the value. For 2 decimal, I have no difficulty.
Next.
322.
Lordship, I am appealing for the petitioner, Lordship. This is my affidavit of service, Lordship. Lordship, my case is that, Lordship, initially my plots of lands were acquired by the state government at the instances of Holdia Dock Complex. Subsequently, that was cancelled by the Holdia Dock Complex.
That was?
Cancelled by Holdia Dock. They said that they no more require the land. Now they have deposited some money with the state government for the initial acquisition process. My plots of land is no more required by the Holdia Dock Complex. And I require OLF because my plots of land are surrounded by some of the plots which owned by the Holdia Dock Complex. They agreed to grant me OLF. Now the problem is twofold. One, the state government is not releasing my lands because the acquisition process was initiated at the instances of Holdia Dock Complex. They said they no more require the land, and they have requested to the state government to cancel the acquisition process in respect of my plots of land. So first, they have to cancel the acquisition process and release my lands, and subsequently, the Holdia Dock Complex, they have agreed to give me grant me OLF, and they will be granting me after they release the lands. So may I, if your lordship, kindly come to page 55. This is the initial notification. Prior to that, there was another acquisition process that was cancelled, but this is the latest one. 55, this is the first gazette notification to acquire the lands. The details of lands, the plots of land referred in the next page, that is 56. These are the LR plots number. These are the plots. These all are my plots of land.
All these plots are your land.
My land. The petitioner is the cooperative society who is the retired or existing employee of the dock complex. They want to build up their houses on that plots. Now, your lordship, kindly come to page 83. This is the initial notification for acquisition. Now, kindly come to 83. This is proposal for acquisition of such and such land. Kindly come to paragraph 2, my plots of land. These are the RS tag number. Lordship, kindly come to straightway 84, paragraph number 6. In this regard, it is now informed that considering the developments regarding the utilization of port land at Moja such and such, that is not relevant. Immediately, accordingly, the proposal of SMPK, Shama Prasad Port, Kolkata, for acquisition of 6 plots of land at Moja such and such, plan cancel and withdrawn. You are requested to take necessary action in respect of cancellation of acquisition proceedings. So this is the letter issued by the Holdia Dock Complex. So initially the acquisition process was initiated. Now they don't no more require my lands. It is to be released. Next, your lordship, I'm just giving nutshell so that it can be solved easily. Then your lordship, kindly come to page 97, plan of the Holdia Dock Complex. This is a letter issued by the dock authorities to district administration. Kindly come to page 98.
Yes.
The proposal was explained to the trustee. Proposal means my proposal to grant me OLF. After discussion, trustees decided to ratify the decision for withdrawal of acquisition proposal of SMPK. Trustees also decided that after receipt of communication from the state government accepting the request of SMPK for withdrawal of acquisition proposal, OLF permission in favor of Agomoni Cooperative Housing Society, that is the petition, may be granted. So I am stuck there. This is, in short, this is my case. They may have dispute between the two authorities. They have deposited some money, state government is not refunding, but my case is that my land is not being used by them, not released by not released by them. So in very short, this is my case. Other documents are there, but
you have twofold prayers. One is for release and the other is for the way leave.
OLF. Well, if so far they have agreed, I am saying that they must not depart from that.
Yes.
Yes, my lord, I appear on behalf of the Union of India. My lord, initially there was a scheme that there will be a huge complex, my lord, of port area. But Haldia Dock Complex, they are under the statute. They are the creature of the statute. They are having independent body. But I cannot say that what they have done, what they are. But what I find, or what I have found, my lord, no, I cannot, because my lord, there is a autonomous body.
It's appearing.
My lord,
Probably no one, but I have served lordship.
Respondents.
my lord, they are the answering. Though,
That's the
my
last
lord, if
page
you-
of my affidavit to service.
So, my lord, if your lordship kindly come to page 105, I believe the purpose will be served by the, if it is adjudicated properly.
105.
105, 106 and 107, they have made the representation on first, my lord, 2nd May, thereafter 19th May, as well as 30th November 2022.
For the state.
Yes, because my lord, initially, my lord, we have issued the memorandum. By the strength of that, the state authorities, my lord, they have proceeded with the acquisition proceeding for the purpose of Haldia Dock Complex. Now Haldia Dock Complex has taken another plea. If that is so, that the dispute between the Haldia Dock Complex as well as the, my lord, the state authorities, that is the special land acquisition collector, they will decide and they will conclude everything.
Consider 109 as well, my lord.
Yes.
As my learned friend is referring my representation, what I
Yes,
have
yes.
done. I have given
That
an
if
undertaking.
that
I have given an sorry.
But if that is considered after giving an opportunity of hearing both the parties, then I believe, my lord, the purpose will be served. If, my lord, subject to lordship's kind sanction, because they have indicated everything. Ultimately, the undertaking has already been submitted before the authority.
I said that I will not claim any compensation.
আরে আমাকে বলতে দাও না, আমি তো বলছি 109, that will be, my lord, the effective, my lord, if your lordship allows that particular portion prayer, let that be considered.
109 is only an
That is their undertaking before the authority. Now it is to be considered. The special land acquisition collector, probably Mr. Dey, is appearing. He can submit.
My lord, all the petition which he filed, my lord, all petition will be considered by the district magistrate.
That I have. That will be, my lord, effective, my lord,
Not been
subject.
considered. Lordship, that is pending. That is pending till 1992. Initially, they have initiated one acquisition process that was cancelled. Then they have.
If that is,
within 1 month.
Within 1
yes,
month.
my lord,
that
within
will be
1
solved
month.
by-
State will decide
Within 1 month, because, my lord, it's a.
and take all consequential steps.
Lordship, what I was submitting, Lordship, because the land, for the purpose land was acquired, they have said that they no more required and they have requested cancel. What I'm afraid of, Lordship, because then I have to show other documents. The conflict is going on between the state and the dock authority. No. Let me something. The conflict is because for initial acquisition, the Haldia Dock Complex Authority have deposited 50% of the cost, like 60 lakh or something.
In that case, will you try serving the Haldia document?
I have served, I will serve again.
Once more?
Yes.
That will, my lord, go another 1 month.
Because unless the dispute, what?
Otherwise, my lord, if you
Yes, I will serve again.
Is to direct the DM to consider.
No. I will serve again, but unless the dispute between two authorities is resolved, going back to them, I believe will be.
বলছি তুমি কি বুঝতে পারছো?
হ্যাঁ, আমার representative
বলছি যে তুমি যেগুলো ফাইল করেছো সেগুলো কনসিডার করা হবে বাই দ্য ডিএম।
না সেটা বুঝতে পারছি, কিন্তু আমি বলছি যে that is not being done, that is then I have to numbers of letter written by the dock authority to them.
The Haldia Dock Complex has already de-requisitioned your land
Yes.
and informed the same to the state.
Yes.
So now it is for the state to take.
Yes, take the call.
Yes. So let your representations be decided by the state within a stipulated time, maybe within 1 month.
My lord.
The presence of the petitioner and
the interested parties, whoever it
Then Lordship, the dispute between the two authorities may not come into that.
There should not be any dispute.
Yes.
Because the documents reveal that.
Once they have indicated that, yes, we are.
They do not require the
Then
land
how
has not, they want to release it from acquisition. So these documents.
Also for second fold of prayer, Lordship document authority is required.
Yes.
Second fold of prayer, that grant of OLE. That prayer is also there, Lordship.
Well, if cannot be granted by the late court, can it be? Because my lord, the LA proceeding is pending since 2002.
Lordship, they have agreed to that because they are not stuck there only.
Take up with the authority.
Then, my lord,
I have written, they have come to that conclusion, Lordship. I have to give in that OA leave, Lordship. So that dispute is with them actually.
Yes.
The issue of OA leave, Lordship. This is to be decided by the Holdia Dock Authority.
My lord, only the notice issued to that will be solved the problem. That is, there is no problem. But to see.
I'll record because grant of way leave has been allowed by the Haldia document.
yes, my lord, I cannot say that they have not,
97,
because that
page
is within the
97.
record.
Court order.
Yes.
That since this has been allowed, it is expected that that will be granted.
Yes, my lord, that for such reason I have some.
Disposal of the representation to be granted.
Yes,
Let that be a consequential step taken.
my lord.
Affidavit of service. For learned counsels for the parties. Paragraph. It is contended on behalf of the petitioner
Respondent number 1 only.
that
Respondent number 1. Union of
the authorities of the Holdia Dock Complex initially acquired the land of the petitioner. Three-day notification dated 2nd December 2002. That was the notification by which it was taken.
Yes. Page 55.
Stop. Subsequently,
Page 83.
the Deputy Chairman, Holdia Dock Complex, by a letter issued to the Collector, Purva Medinipur on June 21, 2021, informed that the proposal for acquisition was cancelled and withdrawn. Stop. The collector was requested to take necessary steps in respect of cancellation of the acquisition proceedings and arrange refund of the amount paid by the Holdia Dock Complex towards payment of 50% of estimated LA compensation. The land of the petitioner having thus been freed from acquisition by the authority, the petitioner seeks return of the land in his favor. Paragraph. Learned counsel for the petitioner takes this court to a resolution taken by the Holdia Dock Complex on a proposal made by the petitioner for grant of way leave permission, WAYLEAVE, way leave permission for egress and ingress of the petitioner from / to his property. By resolution dated 3rd November 2021.
Yes, Your Lordship.
3rd November 2021, comma. The trustees decided to ratify the decision for withdrawal of acquisition proposal and grant of way leave permission in favor of the petitioner. Paragraph. The petitioner submitted several representations before the Special Land Acquisition Officer seeking you have sought release of your land. Release of his land and issuance of no objection certificate so that he can proceed to construct the housing complex on the said land as contemplated. Stop. The representations are yet to be considered. The petitioner has prayed for a direction upon the authority to consider the representation at the earliest. Stop. The petitioner has also given an undertaking before the LA Collector Holdia and Special Land Acquisition Officer by a letter dated 22nd August 2022 that he shall not claim any damage suffered in consequence of the proceeding of consequence of the acquisition proceedings. In consequence of the acquisition proceedings. Paragraph. Learned counsel for the state respondents submits that the 7th respondent, the collector should deal with it.
Yes.
The 7th respondent be directed to deal with the representations submitted by the petitioner in accordance with law. None appears for the whole year of complex despite service. Affidavit of service, none appears for the whole year of complex despite service. Paragraph. In view of the above, the petition is disposed of, directing the 7th respondent to consider and dispose of the representations made by the petitioner within bracket annexure P13 to the petition, bracket closed, within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the Holdia Dock Complex authorities, comma, in accordance with law. Paragraph. Upon disposal of the representations, comma, necessary consequential steps be taken by the authority within a month thereafter. Paragraph. Since the Haldia Dock Complex authorities have agreed to provide way leave permission in favor of the petitioner, comma, it is expected that such permission be granted.
My lord, after court, whether they have any right to withdraw that. If that is a judicial proceeding, my lord, they can do so.
To
Not that
withdraw
is, my
what?
lord, I play, my lord, that at the that is the magistrate will consider, my lord, in the presence of both the parties. Your lordship will not.
That is, they are trying to go into that
No, no,
dispute.
way leave cannot be considered by the district magistrates. The leave of way to their property cannot be considered by the district magistrate.
Hold the dock
District
complex.
Magistrate will consider the representations in presence of both the parties. I'm just adding a line that since the Haldia Dock Complex has, they have agreed to provide him with way, leave of way.
As there is a bar, my lord, there is a.
Lordship, that is not nothing to do with state government.
My lord, if you
And this has nothing to do with the government, the state.
Yes.
This will be done by the authority, the
Hold the
Haldia
dock complex.
Equivalent since the such permission shall be granted to the petitioner immediately upon release of the plots in question in favor of the petitioner. Disposed of which are clear.
My lord, if that is done by the TM,
Way leave cannot
no,
be
no,
done.
no, no, my lord has just now indicated if the release is done. The
That is the
release in
respondent
respect of the entire property consequence.
Consequential. If there is no release, nothing happens.
Yes, my lord. But no affidavit has been called for such reason, my lord, the allegations.
That will be recorded.
My
Those
lord,
are the
I'm
usual
grateful.
lines.
I'm grateful.
No, group one motion.
Any origin side mentioning?
All the bases.
Code application, serial number 1, Benu Binod Mike.
তুমি টাইম চাইলে হবে না সবসময় টাইম চাইছো
আমি
না তো তা ভয়
my lord, in this matter, Mr. Debra is
Kindly
appearing.
appreciate one thing. This has been already been decided by your lordship in the other courts also. The case is that, my lord, 13 years old permit that has not been renewed. They declared, they cancelled that permit. My application rejected on the ground that there was no vacancy. My lord, on the last occasions, my learned friend, my lord, Debra also, my lord, taken this issue.
Debra is not there today.
No, he's there, my lord. He's engaged in courtroom number 42, my lord.
Well,
Especially
I
this
have to
matter, my lord,
place
is there.
judgment. Nothing is there. Your lordship has already, they have told that it has to be considered.
On the earlier
Now, my lord,
date,
then, my lord, let me place.
you had taken an adjournment. So
Not on that. He was.
are you ready? Are you
No,
ready?
my lord, I am not.
No, my lord, there is no such. Your lordship, the decisions.
Come back some other day.
My lord, your lordship kindly appreciate decision has been communicated to. Well, your lordship, they decided. My lord, the
Can I hear
report has
this in
given there.
absence of the other side?
But I only place to judgment, my lord.
You will do everything on the next date.
I
Be
only
present
place to
on the other
judgment.
side.
Let this judgment be considered by my learned friends.
You can
Then
hand out a copy today. I'll not record anything in today. He's generally present here in court. Today he's not there for some reason. I cannot take up the matter in his absence.
দিয়ে দিন না judgment দিয়ে দিন
না, তারপরে এখন দিয়ে দিব। গ্রসারি record না করলে আমি আর judgment দিতে পারবো না।
On prayer of the respondents, the matter is adjourned. Paragraph, let the
আজকে
matter appear under the same heading on
Original side. তাহলে আর কবে হবে?
next Thursday.
Next Thursday.
My lord, the next Thursday is a holiday, I think so.
Next Thursday is a sectional holiday.
No,
don't have
as far as,
holiday, Mr.
as far as I have got the information that the Supreme Court has already, and my lord, declared that is tomorrow,
Supreme
Thursday
Court has declared
20.
a holiday.
Yes, that I have heard, my lord, that.
Okay, let us avoid that date. Let us avoid. So come back on 5th. 5th October.
ওরকম একটা accidental
Yes,
দেখে
next
তো
slide.
কোনো আপনি ফোন।
2, Sombit Basu.
I'm a proposed statement. Yes. Ball.
Yes, Mr. Basu, you're repeating.
Yes.
My lord, they have to take instruction because my lord, the case is that, my lord, I was operating a vehicle on the basis of permit. Now I surrendered that permit because of non-viability on that particular route. I made an surrender. I made an application for another route. They considered and allowed, issued an offer letter. Now I placed all the documents which required for issue of permit. Now they, my lord, they inform me by of a memo that your lordship will find at page 5. That is issued in view of page 16, P5. Surrender pending, because the surrender pending due to NOC from the financer, that was not recorded on the last occasion, your lordship. And the my lord, the other, my lord, the my lord, and the dues, what is due? And the traffic cases, that has, I have already annexed that the
You
traffic,
submitted these documents before the authority.
yes, that is there. Your lordship will find that P3 annexer P3.
Mr. Basu needs to take instructions as to why it's
Yes,
not being
sir, I have already, we have talked with them, but no instruction has been received, my lord. So this
So
can
please
be,
come back on the next date with instructions.
কি চাইছো কি তুমি reconsider?
Because despite submitting all the documents, the permit has not been
Questions of reconsider here is not required. Well, this has to be granted. These should either they have to issue.
It's not required.
Yes, that is known.
The petitioner has submitted all the relevant documents for issuance of a permit,
Yes.
but the
That I have
permit has
seen.
not been issued. That is the grievance.
That I have seen, my lord.
Yes.
Only thing remains, well, they told that the NOC, well, there is no provisions at all in the act that NOC from no objection from the financer. It's required. There is no provisions at all. So other things that they have, they told that the traffic violations that I have paid already. So that is that I have annexed. Only
You have
that,
paid and you have submitted documents to that effect?
my lord, your lordship,
The authority?
that your lordship kindly come to page 14.
Page 14.
Documents.
চালানটা কোথায়?
Page 14 is the application.
Page 14 is Mala, the prayer for issuance of permit. There I have enclosed all the documents. And 7 of the documents which I have annexed in page 16. Because page 17.
চালানটা কোথায়? চালান জমা দিয়েছে যে? ওটা চালান। এটা
The documents I all have annexed. Then Mala, the after this Mala, the memo that is at page 16 P5. Then Mala, I got this Mala chalan whereby I deposited the traffic fines all. So that except that all the documents which required under the Mala, the
That was given.
offer letter that has been submitted.
if all the documents have been submitted, then authority will consider check it out. Huh? He has said that all the chalans have paid money. টাকা পয়সা দিয়ে দিয়ে যা যা রিকোয়ারমেন্ট সব দিয়ে দিয়েছে। তাহলে আমরা কি করা উচিত? অথরিটি সেটা এই করবে।
There is an issue of no objection, but is there any provision for it?
লাগবে না বুঝছো?
মানে
ফাইন্যান্স
মনে পড়েছে মানে I had a talk মানে over telephone মানে with the secretary STA. And my lord, they my lord or my entire my lord, the STA secretary, deputy secretary, I talked to them who are the decision making my lord body in respect of this. My lord, they are my lord under my lord they say that since in the rule book there is a provision that at the time of renewal the question of no objection it comes as in terms of the my lord, the West Bengal my lord, the motor vehicle rules book, that at the time of renewal of the permit the no objection has to be submitted from the financier. So according to them, their perception, my lord knows that my lord, everybody has some limit so far the law is concerned. Now my lord, their perception is that since at the time of renewal the financier's no objection is required,
Then why not?
so naturally at the time of surrender of permit, because the bus, my lord, the vehicle, my lord knows that belong to the my lord, the financier in terms of financier agreement. And my lord, he may be the my lord, the registered owner, but as per law, he is the belly. The actual owner is the financier. Now that is why they thought, but my lord, practically my lord, I communicated this that there is no such provision under the law. So I cannot extend the legal proposition which is not my lord, the under the statute or in the statute. So then my lord, I said that whatever the my lord, the order be passed by your lordship, my lord, that will be followed. So I leave it to your lordship that because there is otherwise my lord, they have my lord, nobody my lord stand in the way. 7 except that my lord,
That the NOC is in the.
that the NOC is the PS. I think that is the issue, right?
Let permit be issued in that case.
Subject to my lord for all other compliance of formalities, including the my lord, the documents, my lord, they relies upon in terms of their my lord, the possession and or ownership of the vehicle, everything lordship.
It is contended on behalf of the petitioner that despite submitting all relevant documents before the concerned authority for surrender of his earlier permit and
এই দেখি বইটা আছে,
issuance of
কোন বইটা আছে?
a permit in his favor, comma,
ইস, এ কবেকার?
such permit has not been issued by the authority till date. Paragraph. Learned counsel for
No,
the
no.
petitioner takes this
এটা
court
দেখি, statute-টা দেখি।
to a letter issued by the RTO and ex officio Assistant Director, STA, West Bengal, on 18th July 2023, indicating that the surrender is pending due to NOC capital from financer and traffic cases for the same. Vide docket number 1241 dated 25th April 2023, which are to be provided by the permit holder as early as possible.
Mala, kindly have a look, Mala, section 51, subsection 6 of the Motor Vehicles Act, my lord. This is, my lord, the special provision, my lord, the special provision for, my lord, the vehicles under hire purchase agreement. Entire section 51 caption, at the top caption is special provision for vehicles under hire purchase agreement. Now, section 51, subsection 6 speaks about this, that at the time of renewal and other, but not, my lord, with regard to surrender of permit. That is why, my lord, they were under the, my lord, this চলে যাওয়ার সময় বইটা দিয়ে গেছিল না? ওকে ওকে কার
আমার আর বইপত্র নেই, বেঁচে দিচ্ছি সব।
বেঁচে দিয়েছিস তো?
কেউ আসবে না তো। No one is coming. সাকসেশন নেই, কি করবো?
বেঁচে দিয়েছিস তো?
সাকসেশন নেই, লোকের
Learned Counsel for the
সিরিয়ালের কাজ
subject
করেছিস।
that
মেয়ে অন্য পড়াশোনা করছে, চলে বলছে অনেক প্রফেশন, নোংরা প্রফেশন।
the petitioner has
কি করবো?
deposited
তোর কি জানো
fine/penalty
এটাই কি একমাত্র
in connection with the traffic cases referred to in the letter.
আমি বলছিল কি ওরা হায়দ্রাবাদে সাইকোলজি কি পড়ছে।
Learned Counsel for the respondents submits that in terms of
ভিজে গেলাম পুরো।
that according to the provision laid down in terms of the petition, according to the provision laid down under section 51 within bracket 6 of the Motor Vehicles Act 1988, the registered owner shall, before applying for renewal of a permit, furnish a no objection certificate from the person from whom the registered owner, from the person with whom the registered owner has entered into the agreement.
Hire purchase
The
agreement.
agreement for hire purchase.
My lord.
Paragraph.
My lord, the impure notice at page 16, my lord, I think has been issued, my lord, on the basis of this.
Pending NOC, yes.
Yes. And that is the challenge before your
Paragraph.
lordship.
It prima facie appears that the petitioner has submitted all relevant documents in connection with surrender of his earlier permit and issuance of a fresh permit in his favor. Stop.
In terms of the offer letter,
Uh,
lordship. Fresh permit in terms of the offer letter on,
In his favor in
on
terms of the
another route, another.
offer letter issued in his favor. Stop. There is no provision for issuance of NOC by the financer in favor of the petitioner / registered owner
In case of,
in the statute for surrender of permit or issuance of a fresh permit. Both are not there.
both are not.
Paragraph, in view of the above, comma, this court is inclined to hold that the authority be directed to accept the surrender of permit by the petitioner and take necessary steps for issuance of a fresh permit in accordance with law. Paragraph, accordingly, the petition is disposed of.
Subject to, my lord,
I will-
subject
I
to
will.
submission.
The operative part. The secretary.
Yes, issuance of permit, secretary, because there is no question to refer the board.
Fourth respondent to accept surrender of the earlier permit by the petitioner and take necessary steps for issuance of a fresh permit in his favor, subject to the petitioner complying with all requisite formalities and submitting relevant documents as required under the law, comma, without insisting upon issuance of NOC by the financer.
My lord.
Financer, comma, within 1 month,
Within a month, yeah, my lord.
within 1 month.
Within a
from the
month
date
from
of,
the date of submission of this.
submission, it is already
Within a month from the,
Vehicle is standing idle.
within a month from the date of communication of my lord's order. My lord's
It's
order.
a ministerial job.
within a month from the
But
date
কথা
of
না বললেই নয়।
communication of this order, comma, in accordance with law.
পুজোয় কি বাস চালিয়ে ঠাকুর দেখতে যাবে?
The writ petition being WP such and such is accordingly disposed of, which is chapter 9 boli last. জানেন তো?
গেটফুল মানে গেটফুল। এই এক মাস তো লাগবেই, কি মারছিস?
Urgent certified website box. ওইটা ফেরত দিন। ওই ফেরত দিয়ে দাও, আছে।
এটা আমার নয়, ওই যে কি দিল?
Next.
3. The new Birbhum Coal Company Limited and another.
Three, yes.
I'm for the petitioner, my lord. I'm constrained to pray for an adjournment because of the reason the advocate on record, Mr. Jain Mana, who is octogenarian, my lord, and he has been serious cardiac arrest has been made. He is completely bedridden. That is why kindly after vacation, my lord, kindly fix the matter after vacation.
Have you served the respondents?
My lord,
Is service complete? I do not find it.
respondent appeared in earlier occasion. Respondent has appeared, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on
After vacation, my lord.
23rd November.
23rd, my lord, 23rd. There is some difficulties on my part, my lord.
30th is the next Thursday.
After vacation. Well, thereafter, next week,
Thereafter,
I mean,
7th December.
27th December. No
Yes.
problem.
7th December.
Four. This is Jagruti Components Private Limited and others.
By Mr. Raghunath Chakraborty. On the last occasion, the
Yes.
lordship was pleased to direct, the KMC authorities have short time to take instructions and we asked for certain reports.
Yes. By Professor Pankaj Kumar Roy.
We sort.
Who is appearing for the KMC?
My lord, I am appearing, led by Mr. Alok Thomas. Certain records are there, but my lord, the prayer and the other factual aspect, Without APTP, that cannot be dealt with
Yes, you
because
were
there are so
supposed to
many.
come back with that report.
That report is there, my lord. That is the report.
It's not supported by an
Uh,
affidavit.
My lord, APTP report.
It has to be supported by an affidavit.
My lord, last order, your lordship kindly see your lordship's last order, 31st August.
Yes.
A learned counsel for the seeks to take instruction in this regard. My lord, your lordship's last order, your lordship. That is my instruction. I am handing over. But APTP report is not there, my lord.
Have to hand over certain documents to the petitioner. Have you done that?
No.
If this is the instruction, it can be taken on record.
This
But
can,
There is a, please come, you've read only the last line of the order. Please read the earlier parts.
my lord, that is 31st August order.
Yes.
My lord, APTP service taken on record, order passed by KMC is assailed in the writ petition. My lord, that is the order.
After that?
That my lord, learned counsel for the petitioner submits that in the order impugned, the authority has relied upon National Remote Sensing Agency and a detailed report submitted by Professor Pankaj Kumar Roy, School of etc., Jadavpur. Besides other documents, copies of which have not been made over to the petitioners, they are learned counsel. My lord, thereafter, my learned counsel for the KMC seeks to take instruction in this regard.
Hand over these documents to the petitioner.
My
They
lord,
rely on certain documents.
my lord, that I can hand over this document. My lord. I should. But that direction is not there in your lordship, even not in oral your lordship. I was in the impression your lordship first time of is satisfied and then I am.
No, because the petitioners have to.
And
make
he
some
should. I will. I
Yes.
will. Your lordship kindly take this
Only, my
matter.
lord, we are praying, my lord, let there be, my lord, at least a status quo order may kindly be given, not to take any coercive action by the Kolkata Municipal Corporation. My lord, it is their duty at the very outset when the hearing was taken place to hand over relevant document. That was not done.
Please show me the impugned order.
My lord, kindly come to page 79. Page 79.
Find out whether an interim order is
My
necessary.
lord, yes, because of my lord, kindly see, my lord, last paragraph may kindly be looked into. 82, last paragraph. After leaving 3 line, my lord. Lordship got it, page 82.
Yes.
So it cannot be said that an executive engineer C and EH issued notice which is devoid of any facts. Therefore, the petitioner must be restored the water body to its original condition within a 30 days from the date of receipt of this order and maintain the water body following the Inland Fisheries Act. Well, this is not a water body directed, my lord, to restore it, and the hearing is not completed. The golden principle not complied with, my lord. No document, nothing of this, my lord. The Jadavpur University report and other things, my lord. It should be done in our presence.
On the basis of this order, interim protection is not required at the moment.
Lordship.
Come, let them find the documents.
They are
It's come back.
taking time, at least on 3-4 occasion matter is, my lord, before this honorable court.
Before the next date, please hand over the documents.
That document.
Yes.
Or otherwise, your lordships kindly see this sort of writ petition, can it be actually disposed we basing upon only report or APTP in opposition and reply? That is better. And one status quo, because he is trying to fill it up. That is our complaint. And his complaint, I am actually restore it back.
With regard to nature and character.
Character, that will shape both and APTP direction. Along with APTP, then the record will be there automatically.
Learned counsel for the KMC seeks to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be submitted. Please annex all the relevant
All the
documents.
document, that should be, otherwise our APTP.
Opposition be submitted within 2 weeks after the vacation,
My lord.
within 2 weeks after the ensuing annual vacation. Paragraph, affidavit and reply, comma, if any comma, be filed within a week thereafter, Paragraph, let the matter go out of list for the time being. Liberty to mention, stop. Paragraph. Since the order impugned
Page
directs
79.
the petitioner to restore the water body to its original condition within a stipulated time frame, and learned counsel for the KMC submits that the petitioner is trying to fill up the water body expeditiously, comma, let there be an order of status quo upon both the parties in respect of in respect of the nature and character of the water body in question as on this date until further orders.
May I take back the report because so only one copy, Lordship. I'm sorry, Lordship.
Please come back with the affidavit.
I am grateful, Lordship.
Deeply up.
After.
Assignment. ও অ্যাপ্লিকেশন বেঞ্চ এসছে বেঞ্চটা দিয়ে দাও সামনের বেঞ্চটা দিবে আর ডিভিশন বেঞ্চ একটু আমাকে ফাইলটা পাঠাও আমি একটু দেখে নি কি আছে